Let's go ahead and get started. I have the privilege of introducing to you Susan Orendac. She has over 3 decades of experience in the field of community corrections, which means she started when she was 8 years old. She's the Assistant Deputy Director of Field Services for the Harris County Juvenile Probation Department. She is former Regional Field Coordinator for National Institute of Corrections, the Southern District, and currently holds certificates in numerous training curriculums. Susan is a member of the Motivational Interviewing International Network of Trainers and has worked extensively with numerous agencies across the United States to develop effective and sustainable motivational interviewing implementations, which is understandable considering when I first met her after I took over the juvenile division, I saw her at one of these like lead programs or one of the 5 million committees I'm forced to be on. And she approached me with this motivation. I'm so glad you're here. Can you help me? I can help you in any way. I'm your resource. So she's an amazing resource to have, and we're glad that she will be kicking off our Saturday morning. I give you, Susan.
Thank you. Wow, that was very nice. Thank you. Is Steve in the room still? Where are you, Steve? Maybe he's out. I either need to blame him or blame my boss, my chief, Henry Gonzalez, because somebody asked me to speak at the law conference. And I'm like, yeah, no problem. I office in this building. Okay. So Steve sends me the information. I send it back. I'm good, right? Then he sends me back the time, 9 o'clock on Saturday morning. I'm like, what? So somebody messed up my Friday night margarita night. And I could have gone earlier, right? But I have my baby, my second child is a senior in high school, graduating at the end of this month, and last night was senior night at the baseball game, and he plays varsity baseball. So I could not join the other parents. So somebody really owes me one of those big, fishbowl-sized margaritas. I'm not sure who. Maybe it's Steve, maybe it's John, and Henry. So maybe I'll get 3 out of it. But I'm really happy to be here this morning. I was asked to talk about our community resources and placements, but I think it's very fitting. So how many of you do work in juvenile justice? Probably everybody in this room, right? So how many of you have seen our name, Harris County Juvenile Probation Department, in the news quite a bit, right? So this is our word for the year and for next year and for the year after. It is called transition and reform. I can't think of a better place to be in right now. This is my 30th year in the field of community corrections. I spent 27 years in adult probation. I know some of you, Rebecca and Mike and some of the other ones in here. I even knew Jerry Acosta's dad when senior Jerry was young. That's how old I am. Remember Rebecca and Mike when Jerry used to be really young? So I'm excited. We were young. But I'm excited about where we're at today in juvenile probation. I'm really excited that, like John said, I'm a motivated person, but I've seen when I came into the agency, we were extremely compliance-driven in not only in our correctional facilities and our youth facilities, but in the field. And we have been able to make some transitions in the preceding years, and now we have a brand new juvenile board and brand new juvenile judges and a new chief. And what we've done internally is we've also changed our upper leadership. So we have a new director over facilities. We have a new director over field. We have a new assistant deputy director over field. We've got new divisions, and I think this is just a great time for us to make transitions. So what I want to do today is talk about not only some services. I've given you our annual report, which our annual report that you have in your hand, hopefully everybody has a packet, is from 2017. Next week, our 2018 annual report should be we should have it by probably next week. So we always work a year behind, so that when we get the report next week, it'll be reflective of 2018. But it's still a very good resource for those of you that are not as familiar with our department. I would urge you to take some time to look through that, to read it. It will tell you all about everything that is going on in our department, from our education in our facilities, to our JJAEP, to our service learning, to the field, forensics you heard from yesterday, and just a variety of things we have going on. So despite what the media wants to say about us, I feel like we have a great department with great services. So what I want to do today is really look at the points of our reform, and then talk to you about some things we've already have in place, and then at the end give you some resources. In your packet, you do have a sheet that has a variety of different resources. That's not all that we use. Those are more of community-based resources for you. I'm also going to give you the link to our hcjpd.org website, and when you go on there, you can click on resources, and you will have online resources for your kids and families that you deal with, everything from housing to substance abuse to human trafficking, and those are all community resources available. So those are going to be some resources that you can have. So want to talk about our first point. And this reform that we've adopted is not something that we've just came up with. It actually comes from the National Institute of Criminal Justice Reform. And if anybody's interested, there is I printed out the whole research brief, and it's there. You can look at it, get the website if you're more interested in it. But it has 10 guiding points, and I want to go over those with you and then tag in. I only got 45 minutes, so I'm going to try to move pretty quickly and also save time for some questions and answers that you may have. So the first point that I want to talk about is keeping kids out of the system. So I'm not sure if other speakers have talked to you about this so far, but what we've done in our own department is we've divided our deferred adjudication cases and our adjudicated cases into two divisions. So now we have a diversion and intervention division and an adjudicated division. And so people might be saying, well, I don't care. What difference does that make? So in an adjudicated division, that's my division, these are kiddos that have been adjudicated. They're going to be likely your more serious cases, all right? And so in our deferred division and our diversion and intervention, these are kids that we're really trying to keep from going deeper into the system. So one of the things we've worked with, we're working with them now, but the district attorney's office has really been on board with trying to keep kids very shallow in the system. So one of the things that we've just launched this year is a program called FIRST, which is a family violence intervention program. So kiddos that have these minor things that go on in their home, instead of having a formal referral, they're put on the FIRST program, and they're connected to immediate services through MCOT, which is through MHMRA, the Harris Center, and we're keeping them from actually being in the system. So there's no referral at all if they complete it. So that's one of the programs that's going on in that area. We also have been working with Law Enforcement Assistance and Diversion Program, which is a program that is in Addicts Middle School right now. And in lieu of kids being brought in on a formal referral, if appropriate, they're referred to the LEAD program. So that keeps them from coming to us. And that's been pretty successful so far. We have a probation officer that actually is working with the school. Even though the kid isn't on formal probation, there are some other kids who actually at Addicts are on probation. So that probation officer collaborates with the LEAD staff and also works really closely with the principal. That initiative is not only through the district attorney's office, but also through Houston Revisions, which is one of our community partners. Another program that is trying to take shape right now is in the Fifth Ward area. They have a whole group of people that are working collaboratively in the same fashion kind of that the LEAD program is, to provide intensive case management to kids in the Fifth Ward to keep them from formal referrals. And so these are just some ways that I feel like we're really trying hard, because once the kid, as y'all probably already know, once the kids get in our system, it's almost like a vicious cycle, right? And so if we can keep them from coming in the system and provide some alternatives to manage behaviors, then we can probably keep them from coming back. And so that's an initiative that we really have been working hard on. Questions about that one? All right? So the next point that I want to talk about is we have, so I talked a little bit about our department was very focused on some kind of the compliance end of things. And so now with a new vision, it is really working with the kids and the families. And I want to say this is my vision for my area is working your cases, right? And so as an assistant deputy, I'm much more interested in somebody working their case than entering their data, right? And so what that means is we want our juvenile probation officers to be out in the community. We want them to use multi-use service centers. We want them to be in the kids' communities and seeing those kids versus waiting for the kids to come in, right? We want the officers to be out there working with the families. We've set up several family enrichment programs, and so we're hoping to really engage the family much more than we ever have before. And that takes the officer being out in the community and that expectation for them to be out in the community. And so part of also what we're doing is we have a new assessment tool, and part of that has a case management, case plan system built into it. So we're addressing the criminogenic needs of the kid, and we're making sure we're not just going by our gut feeling. We're actually ensuring that the things on the case plan are addressing those factors that are most likely to get the kid back into trouble. And we'll talk a little bit more about that assessment tool a little bit later in the presentation. I think Jerry talked to you yesterday, right, Jerry, about the pre-screen, which is the same part of the assessment. So, again, our mission and our big transition is really to be more out in the community and not sitting in our offices waiting for kids and families to come in. Okay, this is the part about the assessment. So in your packet, you have a one-page overview of the PAC, all right? So the Positive Achievement Change Tool isn't just something Susan came up with and thought it was a good idea. This is actually a validated tool. It came from the Washington Risk Assessment and has been validated and normed and then automated into a tool that is now called the PAC, the Positive Achievement Change Tool. This is something that across the state, our governing body, Texas Department of Juvenile Justice, has adopted. So every county in the state of Texas is using the system. So if we have a kid that we get as a courtesy supervision, say from Denton County, we can go online and have them send us the assessment. So it's kind of seamless supervision. Same thing if we send a kid to another county, we'll be able to transfer their assessment. So things about the PAC. So we've developed a whole new matrix for number of contacts based on where the kid falls in the PAC. So in your packet, if you want to pull out that one-page sheet, at the bottom of the one-page sheet, you're going to see a scoring matrix, all right? So to the very far, is this my left or my right? This side. What is that? My right. Is the criminal history score. So the more referrals, the more serious the offense is, the younger the age of first arrest is going to drive your criminal history score. All right? So kid is 13. Hold on. Yes, ma'am? There we go. If a kid is 13 and is picked up on a felony weapons case, criminal history score is going to be higher than a kid that's 15 and gets picked up on a misdemeanor, right? So your criminal history score could go from 0 to 31. So you can see that the criminal history bears a lot of weight, right? At the next intersection is the social history. So the social history are dynamic things that can change. There are some static things in there, but the dynamic factors are going to drive the score. So those are things like mental health, school, history of trauma, substance abuse, gang involvement. And so the intersection of the criminal history and social history is where they land in terms of being high, medium, and low. So recently, in the last month, what I did is I've given each high, medium, and low section a phase 3 and a phase 4 so that we can actually lower supervision within that whole high, medium, and low risk level so that we can reward the kids for good behavior. They may still be a moderate, but they might not have to report as much because they've made progress. So I think that's something that we're really going to be looking at. We don't want to over-supervise the kids because it's like when you have your own kid. If you micromanage them, what's going to happen? You're going to catch them getting in trouble, right, all the time. So I think what we want to do is we want to provide an appropriate level of supervision to the kids that really need it, and the ones that don't, we want to kind of leave them alone and not drive them deeper into the system, even the adjudicated kids, if that makes sense. So that's going to be our focus, too. One of the things that Steve Willing is our deputy, Steve and I really want to look at is how can we keep cases from coming back to court. And so what I've put in place, and Steve and I both, is that every time a probation officer wants to file a VOP on a kid, before they even start to prepare it, their manager, their administrator is going to call Steve or I for approval. And my question is going to be, if it's not a new offense, tell me about what you've already done to work with this kid. And if the kid is AWOL, my question is going to be, what did that officer do to locate that kid? What efforts have we made? And if those efforts haven't been sufficient, somebody's going to be getting in trouble. So that's kind of our framework, is that we want our officers to be working these cases, and that's what we can do, is to try to keep the kids from coming back to the system. Now, as we all know, there are dangerous kids out there. There are kids that need to be filed on because they pose a threat to the community safety. And so those are the kids that we're going to be monitoring closer, that if we need to file a motion on them, we will. But those kids that maybe aren't going to school like they should, or maybe they're still smoking pot, we may not be filing. We probably won't be filing on those kids, because when we do, it's probably not going to make them better. So we want to use our alternatives. We're looking at things like referring kids to unlimited visions, outpatient and inpatient, using every available community resource that we have before our last effort of filing on them.
How do y'all come up with the risk to reoffend? I've had like aggravated robbery, 10-10. Risk to reoffend is high.
So risk to reoffend is going to be, again, your criminal history and your social history. So let's just say you have a 10-10, and he's, how old was he? If you have a 13-year-old, aggravated robbery, so age of first offense is going to be, if you're 12, 13, you're going to, the way that the assessment is scored is that's going to be worth more points than a 15-year-old, because they look at age of first offense, right? The younger you are, the more likelihood predictive of risk to reoffend. So age of first offense, the younger, the more points you get. If it's a felony, obviously, if it's with a weapon, against person. So all those weigh in on the scoring. They're worth points, right? And number of times in detention, that's all in your criminal history, and number of times in our placement. So those are the things that drive up that criminal history. A lot of times when I'm looking at cases, because I like to look at cases because I'm just nosy like that, I want to see what's going on in our field, I want to know those officers are working their cases, I'll see a kid with a high criminal history and a low social history, and I'll say, I don't think so. I guarantee you that kid has some stuff going on. And so most of the time, if they have a high criminal history, they are going to have some social history stuff going on. They may be a gang member, they may have mental health issues, and that may be both. They may have substance abuse issues, that kind of thing. Other questions? Yes, sir.
But outside of just assessment score, what's the factual support behind the actual score? You know, just looking at a sheet saying, oh, he made 95,
Oh,
he made 86.
good question.
You go behind that. And my second
Yeah.
question is, what was done before?
Oh, that's a really good question. Okay, I'm going to answer the second one first, and then go to the first one. So, I think Jerry told you a little bit. So with the PAC, there's a structured interview. So the probation officer is going to interview the kids, 146 questions. They use an interview guide. And then after they interview the kid, they look at any existing collateral information. So a lot of the kids are going to have a psych evaluation. any other collateral information that we may have. It might be a psych evaluation from 2 years ago, but that's okay because we can get historical information. So we don't ever just go by what the kid says. We're looking at all of the information we have available. We'll look at the JOT to determine if the kid was arrested with another co-actor. He can't just have pro-social friends because he was arrested with somebody else that was antisocial. So we use all of the available information to score the PAC. That's how it's scored. And so then once it's scored in the system, then the system calculates those risk to reoffend scores based on how it was answered, if that makes sense. And so the behind the scenes in the assessment, it's hard programmed, right? And the researchers have done meta-analysis on the assessment to determine the scoring weights. And so, again, our staff have no idea what each question is worth in terms of scoring. Some of the questions on the PAC don't even carry a scoring weight. They are there for case management purposes, for case planning. So a lot of those questions are just to give you the kids' criminogenic needs, but they're not weighted. So all the questions in the pre-screen are the same questions that are weighted in the full screen. So does that answer your question?
Well, yeah, but I guess my issue is how do you negate subjectivity? I mean, is it just like ice skating? Oh,
Yes.
I'm a bad breaking on the score.
Yeah.
I give every kid a 9 if they're bad.
Yeah. So good question. So all of the criminal history in that on the PAC is automatically populated through Jim's system, right? So their record of referral, all of that comes in, so it's automatically populated. So that takes out the rater subjectivity, all right? The other questions, again, are collateral information. So we have that stored. So that's one of the things is that the administrators need to be very familiar with the assessment so that they can ensure their staff are scoring correctly. That we've worked on this and worked on this and worked on this. Some of the questions, if the kid is not going to school and he's got 20 absences, he's habitually truant. I mean, there's no question about it. So we're using school records. We're using the psychological evaluations that you heard about yesterday. So we're using all that available information. Part of our case reviews and case staffings that the administrators do with the staff, that's another thing that's changing now. Effective next week, actually, is the managers will staff their cases with their staff, and part of what they're going to be doing is going through that PAC assessment while they say, tell me about what's going on with the kid in school. Tell me about the kid's mental health issues, so they can ensure that that assessment is scored correctly, and when they reassess, it stays scored correctly. Because sometimes probation officers want to either believe it or not, they want to underscore, because the higher the score, the more they're going to have to supervise them. So, inter-rater reliability is something that you're always going to have an issue with no matter what. On the PAC, we try to get between 85 and 90% inter-rater reliability. What that would mean if me and Jerry and John Jordan are all doing an assessment on the kid, that we all are within, 3 or 4 points apart. And I think we're doing, again, it's a work in progress. Because the criminal history score is automatically populated, you're not going to get a kid that we say is a high, but he's really a low, because the criminal history score, again, it comes from GIMS. So that's not subjective. Makes sense? Okay, other questions? Right. To be honest with you, there is a drop down that we can say refuse to participate. I haven't encountered that where eventually the kid doesn't participate, because my experience is if the kid refused before the first court date and he's in detention, he may stay in detention until he agrees to do it. I haven't seen that yet. I haven't seen where the kid just flat out refuses. So I don't know if that makes any sense. part of what is required from the state is to do an assessment of the kid. So that is something that the state requires, is that an assessment is done prior to disposition. And so we explain that to the kid, we explain that to the family, so we do let them know. Right. And then after disposition is when we do the full pack, and that is to help with the case planning process and all the criminogenic needs. I do want to answer your first question. What did we use before? We used a tool, and I'm not even going to say we used, but we completed a tool called the RANA. And that was a tool that the state required us to use. It was not a validated instrument. It was more of a form that our staff just felt like they had to do. And so, I don't want to get into, I'll just do a really quick evolution of assessments because I've got other stuff to, and unfortunately Steve only gave me 45 minutes. So I could talk probably all day about juvenile probation and really the assessment, but really quick. So first, second, third, fourth generation assessments. First generation assessment way back in the day, way back in the day, was gut feeling, I saw this kid come in, his pants were sagging, so he's got to be a gang member, right? No data to support it, just gut feeling, right? That doesn't work very good, does it? We want to make data-driven decisions, and that was no data at all. Second generation assessment only looked at static factors, only static risk factors, right? So those are things that don't change, right? Current offense, arrest history, but didn't look at any dynamic factors. So that's second generation. Third generation looked at static and dynamic factors, and that's what the RANA was. There was 12 questions that had to do with the static criminal history factors and 12 that had to do with more dynamic. That didn't give you a whole lot of information and a whole lot of understanding about the kid's criminogenic needs. So fourth generation assessment is static and dynamic factors because you want to look at the history of, but you can't change it, so that's static. Dynamic factors are things that we know if we can alter that the kid can get better, or if it gets worse, the kid's getting worse. So we want to be able to track and measure that. In our fourth generation assessment tool, there's also a case plan, I think I mentioned this before, component that once we complete the assessment, is telling us what we need to look at with the kid. It's pointing us in the direction of what the strongest criminogenic need is. It even tells us the strength of it. So if it's antisocial behavior, 60%, well, we wouldn't want to target something else if that's what the kid needs most. The beauty of our new assessment tool is it also looks at stabilizing factors, acute stabilizing factors. If the kid is homeless, I don't think we can work on his substance abuse until we get him stabilized, right? If the kid is off the chain in mental health, I don't think he's going to be able to go to a bunch of cognitive groups until we can get him stabilized on some meds, right? So, again, we've traditionally, even though we had some other tools before, probation officers were really going kind of by the seat of their pants and really focused on compliance. Now, we're asking them to really work the cases and understand the kids and give services to the kids that need it. And the ones that don't over-supervise. Does that make sense? All right. Other questions? Yes, sir. I can't answer that one. I have, you know what? I don't work in court, so let me find out about that. Lorandall, do you know? We have our own attorney in here, so I'm going to let him answer that if he can.
Why do you do screenings without first notifying help? Because I'd like to have the opportunity to discuss with my client the kinds of questions you can ask and what sort of things they need to participate in or can agree to or not, and the screenings are done on first-degree felonies and serious crimes without notifying counsel that they're being done.
So the screening is going to take place in two instances. One at intake, where we need to know what we're taking into account, considering what we're dealing with. And at that point, we make that
Yeah, that's true.
until they may not, you don't even know if they're going to be charged. We just hold them to police contact or until the charge is done. And so for our processing, you know, of course, the housing and our facilities will be at that point. And then we'll have post screening, and if the kid gets to that point where he's being screened in the post type situation, he already has counsel. Counsel is already aware, and our lead counsel will have the right to be there for those things. But at intake, we safety, just for safety, we have to do screening. We have to know when we're taking them out of the building. We have to know when we're so counsel will have even screening and all of that.
But I've had screenings done where they've asked kids about criminal history and admissions have been made without notifying counsel.
I can tell you that on the PAC, we're not asking about your prior criminal history. It's there for us to see. So that's what we look at. So when we're scoring the assessment, we don't even have to look it up. It's automatically populated into the system. So we're not asking in the pre-screen interview, we don't say, Johnny, tell me what led you to commit that crime. So we're not doing that.
Maybe it's not the pre-screening, maybe
Yeah.
it's the initial psych assessment you're doing where they're asking criminal history
Right.
forensically.
Right. And I would think, and I might be wrong because I haven't worked in court here, that a youth should have their attorney by the time that they have their psych evaluation. Yes? No? Maybe? Okay. Okay. So good questions, though. We're on bullet point 4, and I have 10, so I need to hurry because I know that Steve is going to come in here and be mad at me, and then he won't buy me my margaritas, so that would not be good. But good questions, and I can hang out for the break if y'all have other questions about the PAC. Okay, so here's where we're also really emphasizing our partnership with our community partners. They should be taking the lead on a lot of these things, and they are. So we have partnerships with Revisions Houston, with My Brother's Keeper, which is an initiative that is run through the city of Houston. We just met with them last week. We're really going to be doing some good additional partnership with them. They provide case management services, mentoring. They're getting kids hooked up with boxing, all kinds of other really great strength-based initiatives. We have a program called PACE that we use, and they provide things like family enrichment. They provide leadership and social skill training for kids. Part of our problem is not that we don't have the services. Part of our problem is getting the kids there, believe it or not. We have money from the state to run programs like PACE and PACE and Embele, and I'm thinking about this dog program. I think it's called something Species. But we've got a lot of money to run programs, and we do run them. It's hard to get the kids to show up, and I wish we had a full-time transportation service, right? That was just a shuttle all over Houston that would go around to these kids' house and get them and pick them up. Because that's a big problem that we have, is getting the kids there. It's not our lack of being able to plug them in. Even today, we have Saturday programs going on at our community-based units. We've got service learning done in a day going on today. We always have things going on. It is a matter of getting those kids connected and getting them there. What I really love to improve upon and increase upon is our mentoring. So if anybody has any ideas on that, please find me at the break. Strong mentoring programs that can work one-on-one with these kids and meet them where they're at is really what we need, and being able to get transportation for them. So community-based programs, we have contracts, we refer out, we have good relationships, I think strong relationships with our community partners. They're willing to sit down at the table with us. My Brother's Keeper, we do case staffings with them. Same thing with Legacy. Harris Center, they're at our offices, staffing cases. The PACE program, the same thing. They're willing to sit down at the table, talk about individual cases, and really work together as a team, and I think that's a really important aspect. questions about our community partners programs? I want to add one thing here, is that we've initiated a new program at all of our reporting offices, and it's called the Community Partner Program. And that is through the Department of Health and Human Services, to where if a family comes in and they don't have Medicaid, CHIP, Healthy Woman, any of those type of Medicaid services, we can now help the family apply directly at our office, so they don't have to go to another location to do that. We're a full-service department now to be able to submit that application. Yeah, I know, 10 minutes. To submit that application for the family. And so I think that's one thing that I think will be helpful. And then we'll be following up with the family to see how their benefits are going and things like that. So that's one thing that we just started about 2 weeks ago. And we have our secretaries trained to be able to do that. So as soon as the family comes in, we're asking them the question, do you currently have Medicaid benefits? Do you need them? And if they need them, then we're applying right then. Okay. All right. So the moment you've all been waiting for. So here's what we don't want to do. We want to reduce the number of kids that are locked up. So I will tell you, in 2018, our average daily population in detention was 247. In 2019, our average daily population is 182. So you can thank our new judges. You can thank our DA, you can thank probation department, because that's a significant drop. That's a significant drop. 247 to 182, we got to be doing something different, right? And our TJJD commitments are down 47%. So what that means is we had a huge decrease in the number of kids in detention, and we're sending 47% less to TJJD. That's huge. So media, if you're here, please take note. All right. So this gets back to what I mentioned earlier about staffing the VOPs before we file them at the field service level. If we can do something different for the kid rather than just filing on him, that's what we're going to do. We're going to exhaust all of our resources and measures to be able to service that kid and family without having to file a motion to revoke on him. So, okay, go. One of the other things that we're hoping and we're urging, and the judges have been open, is to doing more early terminations of probation. So shorter terms. We've instructed our field staff that if you have a kid that is appropriate for early termination, do not sit on that case just because you don't want another one. So you know when you give one up, you get a new one. So we're also looking at those. We're staffing them. That'll be part of the staffings that the administrators do, is not to staff because the kid needs to be filed on, but let's staff it to see if we can get the kid off probation early. Right? Keep them out of the system. Keep them shallow. So those are the things that we're looking at. Okay, moving along. All right. So here's one of the other things that we're looking at trying to do is keeping kids closer to home, using our inpatient resources like unlimited visions versus our post facilities. Also, on May the 6th, not a day earlier, on May the 6th, we're launching a new program called our Serious Offender Supervision Program, and that is going to be for our high-risk kids who would have been appropriate for TJJD or one of our post facilities, but instead the judge orders them to the Serious Offender Program. All right? We no longer have an intensive supervision program. That's a level of supervision now at our regular units. But we are going to launch the Serious Offender Program. And these are kids that are on probation for a felony and that have previously been on probation before. All right? So we're going to be looking to provide a high level of services for these kids. We've got a lot of community partners lined up, and I think it's going to be a real successful program. So what's the difference between ISP and the new program? Good question. I got 1 minute. All right. So intensive supervision program before, for whatever reason, began to get watered down. So you might have moderate or low kids in ISP. Yes, John. And so what we did is we decided that intensive supervision can be a fluid level of supervision. So let's just say that the kid is not doing very well and needs more supervision to get him on track, right? So for 30 days or 2 weeks, we're going to see him at a higher level, right? It's not a program. It's a, let me give him more because he needs it now. So he can be seen at that high level, that intensive level of supervision. The serious offender program is going to have a beginning and an end, and it's going to have 3 phases to it. We're going to have an orientation phase, we're going to have a treatment phase, we're going to have a transition reentry phase. And in all those phases, there's certain engagement things that we're going to be working on. Engagement with the family, engagement with the community, mentoring, job readiness, that kind of thing. So, but not until May 6th. Remember, don't be asking for SOS until after May the 6th. Okay. We've talked about this already, but we are going to be looking at the way we use detention and really only asking for detention in cases that warrant the need, that they're a threat to the public safety. So that's one thing we're looking at. Obviously, our detention population numbers have gone down. So we've been looking at this. We're going to continue looking at this and continue looking at ways that we can keep kids also from going to TJJD. The last one is there are things that we're currently doing that you all might not be aware of in our facilities. We've begun to use trust-based relational interventions that really work with kids that have trauma. We are asking for 2 additional multisystemic therapy teams. It's going to cost about $800,000, but the county actually has voiced their desire to see us have this. We've asked TJJD for the money, so we're thinking that between the county and TJJD we'd be able to fund that, which would give us 2 additional MST teams, 2 teams of 4. So that's a service that really has been showing great results with the kids. So that's one of the other things we're looking at. A lot of revamping in our facilities. We have a new facility deputy director who is a psychologist, Dr. Matt Shelton, and is really looking at what we do in our facilities, even to the point of looking at not using restraints at all anymore. So if we can come that far, it'll be a really interesting time for us. The last thing I want to talk about is, there we go. The last thing I want to talk about is between our 3 post facilities, we have 180 kids. That's how many we have. So we have 3 post facilities with a total of 180 kids. And we have room for many, many more. And so what we're looking at now is repurposing. We are thinking about and looking at, remember those 2 words, thinking about and looking at. Don't walk out of here and say, Susan says. Thinking about and looking at the possibility of turning one of our post facilities into a day treatment center. So the kids wouldn't stay there at night, but they would get intensive services. So 8 million stories, education, job readiness, all the things we do in service learning, the garden, culinary, all those things. And so we are actually seriously talking about that. Yeah, I got 2 minutes. Seriously talking about that. And I think it's a great idea. I think it's a really great idea. Biggest issue would be how do we get the kids there every day? So we'll definitely have to have that worked out. But I think that is a huge viable option for us. And so that's where we're at right now. And we've talked to the Juvenile Board about that last week and mentioned it. We're talking with TJJD about that option and trying to figure out what it might take to make that happen. And so that's an exciting time, repurposing and reallocating and lots of changes and lots of good things going on. It's exciting to work with the new judges. One of them is in here, and Judge Oaks has been a wonderful partner for us. The other juvenile judges as well. I think it's just good things are going to happen. My last thing, and then I really got to go, so I don't get in trouble. John is over there looking at me, giving me the evil eye. Wanted to share with you So if you go to our external website, hcjpd.harriscounty.gov, you will see a dashboard. And on the right of the dashboard, on the right, it says resources. And that's where you're going to find a whole page of everything that you need to know for your families, okay? Also on our main homepage, there's information about sealing of records and all those good things. I don't know if you all are familiar with the Community Youth Service Book, the KAIS book. This is a wonderful resource, too. It's downloadable. And this is the address. Or you can just Google KAIS resource book. It will pop up on your Google. Again, a wonderful resource with lots and lots of community resources available for your families. All right. I think I have like 2 seconds for questions. Questions? All right. I'll hang out at the break if you guys have any questions for me, any additional questions. You can also reach me. My office number, 713-222-4957, or by email. Our goal in field services is to ensure that our staff are working their cases and working with the kids and families. And if that's not happening, I need to know. Steve Willing and I need to know that. Because our mission is to ensure that our officers are doing what we expect them to do, all right, which is working their cases. All right, thank you. Yay!
He has handled some famous athletes, their cases: Moses Malone, Gary Sheffield, Julio Lugo, and it's very impressive. In 1997, Chris was one of the trial lawyers who represented Timothy McVeigh in the Oklahoma City bombing. He's received numerous awards, of which I won't get into at this point, but he is a natural, often guests on Good Morning America, World News Tonight, CBS News, CNN, Fox News Channel, Court TV, and as well as the local media, and he has his own show on 740 AM. The person that does not need any introduction, Chris Tritico. But I think, Steve, did you want to say something real quick? Hold on.
Real briefly, Chris is speaking first on one topic, and then we'll have a break for 15 minutes. We finish up the pastries and coffee out there, and then Chris will come back and talk on another topic for 45 minutes. And he told me after he was actually the first person that got his PowerPoint presentations into me, which was amazing. He did, and he has 2. But he did tell me that if he's ever in a room and agrees to do 2 presentations in one seminar, to slap the living shit out of him. So that's his exact quote. So here is Chris Tritico.
Thank you.
You're good to go.
Good morning. So that lady took up 10 minutes of my time. I don't know how we're going to do this, but we'll see what we can do. I'm glad to be here. That was a joke about the speaking. I'm very pleased to speak about these 2 topics. I don't practice juvenile law every day like a lot of y'all do, but I'm extremely passionate about juvenile law when I do it, because I find this to be the most rewarding area of law I've ever worked in, is helping youth in when they're in trouble. And I am one of the very few lawyers in Texas that practice both education law and criminal law. And so when I get involved in these, and I'm going to talk about school disciplinary issues next, and so when I get involved in these, it puts me in a unique position. They asked me to talk about the interplay between the attorney-client relationship and what happens when mom and dad show up. And I think all of us have that issue when mom and dad show up and they're upset and they're angry, and then you start talking to the kid and they want to be involved. And so that's what we're going to talk about today. Let me see if I can. I'm fat and old, and I don't PowerPoint very well, so let me see if I can figure out how to use this damn thing. There we go. Okay, you got to remember that your client is the child who is the respondent in the matter. It's not the parents. They're only there because they were summoned. All right, they have to bring the kid, but the kid is the client. And their role, the parents, is limited, and this is what causes the friction. And I have this in every case. And so we got to get ahead of this problem at the earliest possible time. And that's at the very beginning. So, I mean at the beginning. And when I start my representation of a child, my office staff leaves the parents in the lobby and brings the child up to my office. And that's where the friction starts a lot of times. And we're going to talk about that. But I just tell the parents right up when they get mad about it, if you want my help, you're going to stay here and I'm going to meet with your son or your daughter. And if you don't like that, take off. Because my client is this young person, not you. And this is how we're going to play this game. And I'm going to help your son, but I'm going to do it my way. And my way is to meet with your child alone. And that's where we're going to, and that starts the relationship with my client. And it shows the client that I am this person's lawyer, not the parents. And that has to build that relationship. If y'all have a question you want to ask me, just raise your hand, yell out, throw something. If you've ever appeared in front of David Hittner, you're very used to getting interrupted. So just say it if you have it. In a juvenile proceeding, the child has the right to be represented at every stage of the proceeding. Section 51, y'all know all this, the family code, the child's representation has the right to be represented at every stage of the counsel. And I hope by now everyone's read the Sixth Amendment. Everyone has a right to assistance of counsel. Humor. Thank you. I know it's early. Y'all had that last lady. Nope, not one joke. Not one joke, okay? We have to have jokes in these things. Thank you. Who laughed at that? Raise your hand if you laughed at that. Thank you. All right, the Texas Bill of Rights in a criminal proceeding, everyone has a right to be represented by an attorney, by themselves, or both. If anyone ever comes to your office and says that they want you to represent them along with them at trial, that's a just say no moment. Recall Nancy Reagan and just say no. We're not doing that. But it's an interesting issue in the Texas Constitution. Oh, I didn't move this, did I? Okay, there we go. Now, what the hell is that? All right, the lawyer's duty. See, I told you I don't do this very well. All right, in the Texas disciplinary rules, the lawyer's duty is to as an advisor, the lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. That's really a unique position for a lawyer in a juvenile matter, because you've got this child who's struggling to understand these difficult legal things. And so when he's sitting there with this fat guy with gray hair and you're talking about legal propositions and you're talking in legalese, and the kid's going, And so you say, you understand what I'm talking about? And the kid goes, and you move on. Well, you haven't helped that kid one bit. You haven't helped him one bit to understand the issues that he's facing, the problems that he's facing, if you just spit stuff out and move on. So my way of doing this is when that kid's sitting there and I'm talking about the problem, that train that's headed right at this kid, I start talking about the issues and I say, tell me what I just said to you. What does that mean? What I just said, tell me what it means. And then they repeat back what they think I just said. Now I can have a discussion on the child's level about what the issues are that this child is facing. Let's bring down to them, at their level, what the problems are, and we can talk at their level about what's going on, why they're in my office, what the problem is, and I can make sure that they understand what the issue is. I'm still alone. I'm still in my office alone with this child. Advocate. A lawyer zealously asserts the client's position under the rules. Negotiator. The lawyer seeks to result. You all know all this. Number 4 is the one I want to talk about. Intermediary between clients. A lawyer seeks to reconcile divergent interests. Sometimes, in these matters, that's between the kid and the parents, isn't it? And so, when you've got those overzealous parents, this is not vodka. I don't do that until 10:30. Sometimes when you have the overzealous parents, you find yourself using number 4 as that intermediary, making sure that the parents are not trying to run roughshod over the kid. And I'm very protective of that, because I'm not going to allow the parents to dictate how this thing's going to end. The decision making is going to be between me and my client. The parents are going to be informed. I'm going to let them know how this thing is playing out, but the final decision has to be made by the client. The law requires it. Even though this kid's a kid, the law requires it. And so that's where we're going to go with this. I keep forgetting about this damn thing. You're not supposed to laugh at me. You're younger than me. That's not fair. All right. Continuing with the disciplinary rules and the rules of professional conduct. Very important stuff. Very important stuff. Nobody ever reads this. It's here. You don't read it until you get that letter. Yeah, that's right. There's a guy laughing back there. You know what I'm talking about. All right. A lawyer should zealously pursue the client's interest within the bounds of the law. Doing so, the lawyer should be competent, prompt, and diligent. For most of us, it's the prompt and diligent part that really gets us, doesn't it? All right, prompt and diligent. That may be a moving target for a lot of us, okay? Prompt and diligent means if DACA calls at 9 o'clock, that doesn't mean 10 o'clock. That's my view. All right, a lawyer should maintain communication with a client concerning the representation. Now, I have found in juvenile adjudication matters that tends to be a slippery slope, because you don't tend to call or go see a juvenile client in jail, I think, as much as you would an adult. And it just kind of slips away because this kid. And I think that a lot of lawyers don't spend as much time with a juvenile as they do with an adult. And I think that's a shame, because that juvenile actually needs more time and more commitment and more talk and more time to talk with than an adult does, because they don't understand what's happening. And so you need to reverse your thinking about what you're doing with a juvenile than you do with an adult, and spend more time with them. And so this communication piece, maintaining communication, if you're going to take these matters on with kids, spend more time than you do with your adult clients to ensure that they know what's going on, to ensure that they understand what they've gotten themselves into and how this is going to resolve, and help them make proper decisions and make sure that they understand the decisions that they're making. Lawyers should keep in confidence information relating to the representation. We'll talk about that some more in a minute. I speak for a living. I know you can't tell right now, but the child is the client. Take a message, please, and tell them I'll call them back later. The child is the client, not the parents. And confidential information. I think there was supposed to be something in there. I don't know what happened to the other screen. I told you I don't know how to do this stuff. All right, confidential information includes both privileged information and unprivileged client information. Privileged information refers to the information of a client protected by the lawyer-client privilege of Rule 503 of the Texas Rules of Evidence, or by the principles of the attorney-client privilege governed by Rule 501 of the Federal Rules of Evidence. Unprivileged client information means all information relating to a client furnished by the client other than the privileged information. That's the hardest sentence anyone has ever written. Acquired by the lawyer during the course of representation. So what are some of the problems? Let's talk about that. What are some of the problems you face with non-privileged information or privileged information and the parents? Anybody? Who said that? I can't see you. Light. Say it out loud.
They want to know everything.
They want to know everything. And so how do you deal with that? I just tell them straight up, you don't get to know everything. All right? I will tell you the things that I can tell you. But my relationship is with this person right here. And the things that we talk about have to remain between us. There are legal and constitutional reasons why you can't know everything. And I'm not going to tell you everything. I will tell you what you have to know. I'll tell you what I can tell you. But my relationship will only remain right here. My commitment is right here. Now, why is that important? Because first, I'm not going to breach my ethics to make some parent happy, even if that parent's writing me the check. I'm not going to breach my ethics for anybody. But second, I want this child to understand that my loyalty is with him. that builds that trust that I need to ensure that that child is going to work with me. He's scared. She's scared. I have to have their trust. They have to believe in me. And when I say that to their mom and dad right in front of them, that starts building that trust that I need to have that child work with me. So when you start talking to the parents, after you've had your meeting, we're going to go into more of the meeting in a minute, do you have your client's permission to share any information? So you have to have that discussion with your client before the parents come into the first meeting. Do you need one or both of the parents to testify at trial? And you have to think about this before you ever share any information. Think about your trial strategy before the first meeting with the parents. Because if this case has if you have any inkling that you might be going to trial, you may want to exclude one of the parents at least from the first meeting and not share any information with them. Because once you've shared it, it's subject to being cross-examined about. So you got to think about that from day one. Because if you do, you may have just blown that information. It's no longer, it's out there. Oh, see, I forgot. All right, no, wait a minute. All right, issues that may arise. The parents are going to want to know what you discussed with their child. They don't get to know. They're going to get mad. That's just too damn bad, okay? It's just too bad. And this starts, and I've had this happen I don't know how many times. This is my child. And they're going to get mad. They're going to get angry. Who's the professional and who's the scared parent, okay? Remember that. And just don't get intimidated. Don't let them get you angry. Just remember, this is the way it's going to work. Or I'm not going to represent your child. If they leave, they leave. Okay, now this is a seminar about getting court-appointed cases, so I know that's a little bit different. But just remember, this is the way this is going to work. I'm going to meet with your child alone, period. And this is how we're going to do it. If they want to go gripe to the court, let them. That's fine, because the judge is going to... Where's the judge? There's a judge in here, right? You're going to support the lawyer on that, right? Was that a yes? It is my firm belief that we now have 3 juvenile judges and magistrates that have actually read the United States and Texas constitutions and believe in it. So that's a very good thing. In other words, as I said, don't get intimidated by parents who are scared and upset for their child. All right? Just remember who the professional is and stay on top of that. Establish rapport with this kid from day one. Ask and use their name. Actively listen to what they're telling you, okay? Don't get on your phone. Don't take phone calls. Don't look at your computer. Pay attention. This is a very scared young person, and they need your full attention. They need you to engage with them only. Ask questions and show empathy for them. Find common ground with this person. And sometimes that's hard to do. Some of these kids are angry. They're angry because they're scared. They're angry because they're not on their meds. They're angry because they've never been on meds. All right? They're angry because they're drug abusers or they're alcoholics. There's a whole host of reasons why they're doing the things they're doing. You need to follow the leads and the cues that you're getting and take those down the paths they take you to discover the situations where they take you. And then you can go where you need to go. Be genuine. Be genuine with these kids. Don't act like you're superior. I know you've all got doctorates and you got more education and you're older than them. Drop down a little bit. Let them like you. Let them like you. Be supportive. Smile. A lot of these kids have never had anyone support them. They've never had anyone that they could trust in their lives. And when you're genuine with them, when you let them in, when you let them like you, it'll be the first time in their lives that anyone has ever let them in. Be that person. Be that person, and you will change their lives. So I've already gone over this. Parents wait outside. It's going to give the client that sense that he or she, that's the only person that's important to you. All right, this is a big screen. Sorry. Oh, wait a minute. Did I pass it? Oh, look at that. Who did that? All right, there we go. Okay. So in that first meeting, as I said, do it alone. Now, you have to have this long discussion about the attorney-client privilege. In that very first meeting, the first things out of my mouth is, have you ever heard of the attorney-client privilege? This is such a wonderful conversation. You ever heard of the attorney-client privilege? In 30 years of doing this, I've never had any kids say yes. No? Well, what do you think it means? The answers are classic. I don't know. It means you're the boss over me? It's a court thingy? Wonderful stuff. And then I just tell them, I ask them, what do you think it means? And I get them to give me just whatever they will say. What do you think it means? And then I talk to them about it. I tell them, here's what it means. You can tell me anything that you need to tell me. Anything you want to talk about, we can talk about. And I will never tell anyone what you said. The law requires that I never repeat what you told me. I won't tell your parents. I won't tell the court. I won't tell the prosecutor. I won't even tell my wife what you and I are talking about in this room with that door closed. That way you can be assured that whatever you tell me will always remain a secret between you and me as long as you never tell anybody. And that means your mom and dad. Because when your mom and dad come in here and say, what did y'all talk about? I'm going to tell them, we're not going to tell you that because we can't. And when you leave here today, I expect you, when your parents say in the car, what did y'all talk about? I expect you to say, Mr. Tritico told me I can't tell you that. And you blame it on me. And if they don't like it, you can call me and I'll talk to them. And they get a big smile every time. You spend the time to make sure that they are comfortable with what the attorney-client privilege is and that they feel comfortable that you're never going to tell anybody what they're about to talk with you about. They have to be comfortable in what you're doing. They have to trust you, and this conversation builds that trust. It builds trust in you that you're on their team. Now, you've built that trust. Be careful, all right, because you've just said to them, no matter what you say, I'm never going to tell anybody. So now we're going to talk about the facts of the case. Control the conversation because you've just told a kid you can tell me anything. I don't want this kid to start blah, and then now you've just messed up my ability to represent you. So now when I'm ready to talk about the facts, I control the conversation by asking the questions and not allowing the child to just blab whatever he wants. Control the conversation at that point. Ask questions designed to let you discover what you need to discover. Help the child through the situation so you get the information you need. Parents still are not in the room. I'm not going to tell you how to do it, but you do that interview your way. All right. So now I spent time building this trust. This has taken a long time. Sometimes it takes 2 hours, more than 2 hours. When I get to this part about the facts, I tell them there's simply nothing you can tell me right now that I haven't already heard, that I haven't dealt with. Quite frankly, I don't care what happened. I just need to talk with you about it. So I'm trying to build trust. What I can't deal with is lies. Because if I get in court a year from now and I built your case around a lie and I find out about it in a year, it's too late. I can't help you at that point if I built your entire case around a lie that you tell me today. So let's talk about things, but just don't lie to me, because I don't care what happened. I'm not going to judge you. I'm not going to think worse of you. I just need to talk about truth. And then I'm still going to lead the questions. I'm going to lead the questioning so I don't get in a conflict situation. But I want to ensure that he or she feels comfortable talking to me, knowing that I'm not going to judge them. I don't care what happened. And when you've represented people in capital murder cases and represented adults in the worst sex cases in the world, trust me, there's nothing a kid can tell you that's going to offend you. Now, Mom and Dad get to come in the room. They have questions. They have concerns. And they deserve to have answers to those questions and concerns. They really do. But now they get to do it only after me and the client have talked. And so I'm going to let them come in. And I'm going to talk to them about it. I'm going to answer their questions. I'm going to do my best to allay their concerns. But I'm not going to allow them to run the case. I'm not going to allow them to make decisions about how it's going to conclude. I'm just going to talk with them about what I can talk with them about. The parents may want a role. They may insist on a role in their child's future. And I think they deserve, their parents, they deserve to have a role in their child's future, but they need to understand that their role, what the hell? Oh, there it is. I think they deserve to have a, I'm going to find the person that did this to me. They deserve to have a role in their child's future. However, they have to understand that their role as parents is diminished by the constitutional protections that their child now has. It was changed once they got charged. It changed radically once they hired me. Okay? At the end of every meeting, at the end of the first meeting and every time in my office, every kid leaves my office with my business card and a pocket copy of the Declaration of Independence and the United States Constitution. I explained to them that I'm now their lawyer. And on my card is my office number and my home number. Those of you who don't have a home telephone number and you just use your cell phone, you're doing a disservice to yourself, because your cell phone is ringing in court and it's taking time away from the client. I know I'm fat and old, but I'm going to tell you this is the best advice you're ever going to get from a fat old guy. Your cell phone is ringing in court when you should be focusing on the person who paid you to be in that courtroom. So I don't give my clients my cell phone number. I have my home number on my business card, and it's an actual phone that rings in my house. We still have those. You can get those. And my office number is answered by an answering service at night. So I tell my client, you can reach me 24 hours a day. I hand them my card, and I say, what do you see on that? And they say, office, toll, I say facsimile, and home. And I tell them, that means, what I say, my office number is answered 24 hours a day, 7 days a week. My home number is answered when somebody's at home. That means you can reach me 24 hours a day if you have an emergency. If you need to talk to me, you have to pick up the phone and call me. If you have a question, I expect you to pick up the phone and call me. I can't answer your questions if you don't call. I don't know you have a question if you don't call. You do not need your mom and dad's permission to call me. Sometimes the dad or mom will say, you have to talk to me first. And I say, no. You do not need your mom and dad's permission to call me. If you want to talk to me, you pick up the phone and call me. If you have an emergency, I don't care what time of day or night it is, you pick up that phone and you call me, and I will help you. I don't care what it is. But I didn't tell them. An emergency is not an argument with your mom, your dad, your boyfriend, or your girlfriend. That's a joke, for crying out loud. Next, I hand them a pocket copy of the Declaration of Independence and the U.S. Constitution. I ask them if they've ever read it. In 30 years, no one has ever said yes. And I tell them, well, it's time you did, because you're about to make very good use of it. And there it is. I buy these from the United States government bookstore. We don't have them anymore. It's online. They're $1.50 a piece. I buy them 100 at a time. And I give them to every kid, everyone under the age of 18, everyone 18 and under that hires me, they leave my office with one of those, and I tell them to read it. It's meaningful. All right? I don't know if they ever read it. I don't care. But it's a meaningful moment. The right to a trial by jury. How'd you like to have that jury? Thank you. All right, for adults, how much time do I have left? Where's the timekeeper? 16 minutes plus the 10 that lady took from me? For adults, trial by jury is a fundamental right guaranteed by the 6th and 14th Amendments of the United States Constitution and Article 1, Section 15 of the Texas Constitution. It's clear, this is really a fun case. It's clear that the federal Constitution does not guarantee a juvenile a right to a trial by jury. McKeever versus Pennsylvania. How many people knew that? I didn't know that. Well, you're a judge. How many people knew that? How many people didn't know that? How many people got enough guts to raise their hand and say they didn't know that? I didn't. Texas does more than most jurisdictions, however, to preserve a right to a trial by jury for juveniles because it's in the Texas Family Code that a juvenile has a right to a trial by jury. So, and apparently most states don't even do that. The right to a trial by jury, at least I looked this time, the right to a trial by jury is afforded to a defendant, not his parents or anyone else. And no one can take that right away. The parents need to understand that this is the client's decision about whether or not he goes to trial. And this is something else that I spent a long time talking about with not only the client alone, but also with the parents in the room. I explain this both in private, as I said, and with the parents. The client has to make this decision, and I make them make this decision because this is a life-altering decision for them. And it's probably the first time in a young person's life that they are faced with something that is going to affect the balance of their life. Even if I know at the end of the day that this case is going to result in some kind of a plea, a delayed prosecution or whatever, I sit them in my office, I go through the facts of the case, and I make them make the decision at the end of the day. And I tell them, I can't do this for you. I cannot do this because you have to make this decision about whether or not you're going to go to trial and pick a jury. Whether you end up in juvenile prison or walk out that front door with me at the end of the case, 3 years from now you have to look in the mirror and say, I made the right decision. And the Constitution I gave you, did you read it? No. Well, you should have, because the Constitution says you have to make this decision about the rest of your life. When you made the decision to do the acts that landed you here in my office, you made the decision that you were going to make this choice today. So let's decide. We'll spend as much time as we have to, but let's decide the rest of your life right now. And we talk about it. This is the time that you can make a difference in somebody's life. This is, as much time as it takes, you can make a difference in somebody's life by spending the time to make them confront their decision making. I want them to understand the importance of it and how it's going to affect the balance of their life. Discuss the reasons to go to trial and the reasons to plea. I'm too scared is not a reason not to go to trial, and it's a crappy life lesson. And that is the reason I get most of the time. And I will not allow them to leave my office on that decision. I don't care how long it takes. It is not a lesson, and it's not a reason. This case is the best case I've ever seen. It came out in 2018. For the Sixth Amendment Okay, we got the right screen. For the Sixth Amendment, in granting the accused personally the right to make his defense, speaks of the assistance of counsel, and an assistant, however expert, is still an assistant. The Sixth Amendment contemplates a norm in which the accused, and not a lawyer, is the master of his own defense. Trial management is the lawyer's province. Counsel provides his or her assistance by making decisions such as what arguments to pursue, whatever evidentiary objections to raise, and what agreements to conclude regarding the admission of evidence. Some decisions, however, are reserved for the client, notably whether to plead guilty, waive the right to a jury trial, testify in one's own behalf, and forego an appeal. We are an assistant, but those fundamental rights belong to the client regardless of how old that client is. And it is our duty to ensure that they understand this and that they are confronted with these decisions. I don't care how tender they are. I don't care how young they are. By ensuring that they understand these rights and by confronting them with it and making them make these decisions, by helping them make these decisions, you are putting them in a position to be confronted with their decision making that got them in your office and ensuring that they never come back to your office. And that is the most important thing that we can do in representing juveniles, is keeping them out of this system forever. And to me, it's the most important thing I've ever done. So in light of the fact that there's no federal or state constitutional right to a jury trial, what are the effects of a case like McCoy? What are the implications on other rights enjoyed by the adult population, and what are the ethical implications of us when representing juveniles? Anybody got some thoughts on that? We got a few minutes. Anybody? Anybody awake? Hello? Come on. You know how long it took me to think of those three questions? Those are impactful questions. Nobody? Everybody's asleep. Here comes the lady with 10 minutes. See? Yeah. You didn't enforce it with the last person. No, I just, when I was writing this, I just thought of these things, and I thought this was very important stuff. Nobody? All right. Well, I thought this was very impactful stuff, but I guess not. All right. Our duty is to help our client, who happens to be a child, make good decisions. These decisions are the decisions that will impact the rest of their lives. This takes time. It takes effort on your part. It takes patience. It takes a lot of patience. Some of these kids, as I said, are angry. Some of them have mental health issues. And we have to spend time to flesh out these things. Flesh out the mental health issues from the anger. Flesh out those that have substance abuse issues from the mental health issues. The biggest driver of the mental health issue of the substance abuse issues is an underlying mental health issue. And we need to, if we figure those things out, we can help that child down the line for a long period of time. And when you figure out the mental health issue and the mental health angle, you can get that child to help and set that child down a path for the rest of their life. There are services for children that adults don't have. There's services at school that you can get for free. There's services with adult probation that we just heard about. Juvenile probation that we just heard about. There's all kinds of services that we can get for children that adults can't get. We can figure this out by doing our jobs in our offices. I have spent time and effort to figure these things out in my office, and I'm no doctor, but by learning these cues and spending time to figure these cues out on my own, I've been able to start identifying these things, and then I tell the parents, let's get your child evaluated. I do it with adults. I want you to get evaluated. When I figure out someone's an alcoholic, I just tell them straight up, how long have you been an alcoholic? Nobody's ever asked them that. Rock back 15 years. Well, let's get you some help. Let's get you some help. Are you yawning and bored, or you have a question? Just do you have a question? Okay. Ask them if they're depressed. Ask them questions about depression and figure it out and get them the help. I'm going to talk about student discipline next, but when you have someone who might have a mental health issue, school districts by federal law have to give them services. And we can get them to a special education lawyer who can force the school district to give them services. There are ways to get these kids help. But it takes effort, it takes time, and it takes patience on our part to figure that out. So, I think we've already talked about this, but spend enough time to make sure that the client and the parents understand that this final decision is the client's. It's not the parents, it's not the lawyers. But I want you to understand that I am not abdicating my role. I'm just ensuring that the kid understands the gravity of the situation. And I'm going to help that kid make that right decision. All right, the right decision will always be made. I'm going to put the kid in a position to make the right decision, and I'm going to help him make the right decision. But I will never let the parents override the decision. And at the end of the day, the law requires us, if the child or the adult says, I want to go to trial, and you know it's the wrong decision, they say they want to go to trial, you go to trial. I've done that. I've never had a kid overrule me, but I've had adults. And I explain, I'm coming to you. I explain to them, here's why I think once they've made that decision, and I've talked about it, we've talked about the case, we've talked about the facts, we've talked about, and then I'll tell them, you know, maybe we ought to look at it this way. Let's look at it this way. Let's look at it this way. And then at the end of the day, if they've made the wrong decision, I'll tell them, here's why I think maybe we ought to look at it, resolving it this way. If they still insist on it, I'll tell them, I'll explain to them, here's what happens when you do these things. And I'll tell them about a guy that I represented in Montgomery County who I said, I think you ought to plea. And he said, I didn't hire Chris Tritico to take a plea. I said, no, you hired Chris Tritico to listen to him. And I'm telling you, you're about to get convicted. And when you get convicted, you're going to get a long, long time in jail. And his offer was 13 years. I got it. And he said, go to trial. He got life. And I know today, when he would be out on parole, he's sitting in a prison cell saying, I wish I'd have listened. So,
Thank you so much for coming to speak with us. I really, really appreciate it. When they don't listen, do you write an opinion letter? And I know that a child is not able
Right.
to do a contract, but as my adult,
okay. Yeah. So she said, when they don't listen, do you write an opinion letter? I've never had a child that refused to talk with me, talk it through, and make the right decision at the end of the day. So I've never been confronted with that. In an adult situation, I always write a letter. Here's what's happening. Here's why I think you ought to do this. Sign here, and I'll be happy to pick your jury. What I don't do in any case is get on the record in open court in front of a prosecutor and a judge and air the fact that I'm having a conflict with my client. I think that that is unethical, and I think it's wrong. Write a letter in your office and have the client in there and sign it and put it in your file. That way, when the client files a writ later, you have that letter, and that's all the protection you need. You do not need to air it in public. I've never had the situation with a juvenile, but I would follow the same thing. Okay. So, in conclusion, this is the most rewarding work you'll ever do. Yes, sir. Thank you. Question was, is there a difference between a 13-year-old and a 17-year-old? Does the sophistication of the client matter? Yes, absolutely. And I treat them in a different fashion. I'm still not going to tell them what to do, but I'm going to spend more time making sure the 13-year-old understands the gravity of the situation than I might with the 17-year-old. And every kid is different. As I said, some of them are angry and some of them are not. And I treat those situations in a different fashion. And a quick story, when they hire me, I treat them in a fashion depending on their anger or they're scared, how they are. I had a client come in one time, and this kid was angry and he was mad, and his dad did not have the money to hire me. He had been laid off, and I can't remember what the kid was charged with, but he needed a shock. He needed a jolt. And so I said, I'll help you. But I knew they didn't have the money. And so I did the contract. And I said, I always make the kid sign the contract, even though he's a juvenile. I make the parent guarantee it. And so I gave the contract to the kid, and he read it. And I said, now, how are you going to pay me? And he looked at his dad. And I said, why are you looking at him? He didn't do anything wrong. What did he do? Why should he pay me? I said, how are you going to pay me, young man? He said, well, I don't know. I don't have any money. I said, well, that's a problem, isn't it? And I said, well, do you have a job? And he said, no. I said, well, here's what we're going to do. We're going to reset this meeting for a week, and you go find a job. Come back in a week. So the family came back in a week, and I said, you got a job? He said, yes, sir. And I said, how much money are you making? He said, I get about $200 every 2 weeks. I said, good. For the next 6 months, you're going to come in here, and you're going to give me $200. And I lost a ton of money on this case. But the dad had been laid off, and I made that kid come in and give me $200 every 2 weeks for 6 months. But it was the most meaningful thing that ever happened to that kid. All right? And that's what we can do. I don't have time to finish this. That's what we can do, is by being a little bit outside the box, you can affect kids' lives and you can change it. And I want to read one thing to you. Every time I read this, it breaks me up, so I hope I don't. I'm about to anyway. Let me find this. This is a part of an email I got. This kid was about to get charged with sexually assaulting a girl in school. The parents brought him to me. And he didn't want to do anything. He just wanted to hide. And I said, we're not going to do that, son. You have to stand up. And the dad wrote me an email. Blank learned many valuable lessons throughout this ordeal. The biggest one was being what you said to him the first day. Right is right. I think giving him a copy of the Constitution was life-changing for him. He learned it's not worth the paper it's written on if we as a society become apathetic about enforcing it. Going forward, I think he will be much more aware of how his actions may be perceived by others, despite his true intent. He was already a great kid, and this will make him even better. We appealed his student discipline and won, and Harris County denied prosecution, all because when he came in and said, if I appeal this, they're going to charge me. I said, young man, if you didn't do anything wrong, you need to stand up and you need to fight. So you tell me right now, if you did this, I'll help you. But if you didn't do it, then you stand up and say, I didn't do this, and let's fight. And that's the end result. So if you're gonna help kids, this is not a place to come in and plea bargain kids out. This is not a plea mill. You be innovative and you help them. Thank you very much.
Chris is going to talk again, but I wanted to, something that didn't come up, and I want to sit here and get his PowerPoint ready, but something that didn't come up during his first talk, which is very, very interesting, which tied in to the parent-child or grandparent-child relationship, probably the most consequential juvenile case that's ever happened in Harris County, Chris was involved in. And so while he may not be down here every day doing juvenile work, the amount of work that he did in this one single case is probably more than people have done in a lifetime who are down here every day doing juvenile work, and that's the Eric Loester case. For those that don't remember this, back, I want to say it's about 2002, 2003, Eric Loester was a 10-year-old boy that was accused of shooting and killing his father. The father and mother had been separated. Very, very bitter custody battle. Father would come and pick the kid up, And on this one particular day, somehow there was a gun in the mother's house, which there was allegations the mother made available to the child. The child, the 10-year-old Eric, had the gun with him when he got into the back seat of Dad's vehicle, sitting right behind Dad, and he ended up pulling the gun out and shooting through the seat and killing his father 6 times. To say it was not only a sensational case here, but nationally, to have a 10-year-old boy accused of killing his father, it was a humongous case. And Chris was Eric's attorney. What was interesting was that there was grandparents on the decedent, on I forgot Loester's father's name, but his parents wanted to hire an attorney out of Galveston. And I remember this, like I had just started doing criminal defense, and I was doing juvenile work, and I would see this kid. We were in the old building, the Family Law Center, and this kid was 10 years old. He was this tall, and he was in the detention center, and he wasn't getting out. So he was there for 2 years while there were all these legal wranglings on the case. And he would walk by me, and we all watched him grow up in the detention center. But he started off this big. He'd walk in the hallway. You're like, oh, everybody would whisper, that's the kid, that's the kid, that's the kid. This was the most famous case going on. And one of the biggest issues and why things were delayed is that the family of the decedent brought in a lawyer. Well, Chris you were hired by the mother, right? Deborah. And I will tell you, Deborah was a nut job. I mean, she became well known to the court. Nobody liked Deborah. No one liked dealing with Deborah. As a matter of fact, the court appointed Brian Fisher as the guardian ad litem because the mother was so difficult to deal with. Now, what's fascinating is that when this murder happened, Judge Ellis was on the bench. This was assigned to the 315th. And then this case is going on. Now, that little ditty with the fight between the lawyer that the grandparents hired, that became a suit that went all the way up to federal court. Texas Supreme Court all the way up to federal court. Just for the right for Chris to stay on the case, the grandparents were trying to intervene and bring in their own lawyer. So you had this nasty battle, and this kid's just sitting in the detention center with this murder charge. And the state, obviously, they go to the grand jury because he was too young to certify. As you learned from Ryan's beautiful presentation yesterday, can't be certified at 10 years old unless it's discovered over the age of 18. But he was 10 years old. So determinate sentencing was the only thing available, punishment up to 40 years. So he is now the lawyer. Brian's the guardian ad litem. They go to trial. Before trial, Judge Ellis suddenly retires. He's the incumbent. He leaves before the election. The governor appoints Judge Snyder, you all recall. Judge Snyder didn't have any criminal experience. He was a county attorney doing CPS cases. This was Judge Snyder. He inherited his first trial in juvenile court. And there's Chris Tritico on one side and all this mess. And when they picked a jury, they went through 1,700 jurors to pick 12. They brought him over in increments of 100. I remember all this stuff going on. I mean, Chris has helped me refine some, but I remember when this was all going on. I mean, there's a lot of people in the room that remember the Loester case. I mean, it was famous down there. So they go to trial. I think he was, 12, 13 years old when he finally went to trial? 12 years old. So Chris brought up a 3-month trial, 3 months. He was convicted. But Chris had a wonderful appellate issue in the middle of trial. He was trying to get experts and the court to pay money because Chris did this for free. He was trying to get money from the court for experts on self-defense. And Bill Hawkins was prosecuting it. He was division chief. Then he was prosecuting the case. And they fought against that. And Judge Schneider, great judge, but he was a little fresh. He denied it. He denied him funds for an expert. Oh. He gave me $100,000. Correct. He denied the jury charge on self-defense. He wouldn't let the expert testify as the state of mind of the defendant. And I said on the record, if you do this, the case will be reversed. Right. And of course, Loester was convicted, got 12 years. TJJD goes off to TJJD, and Chris files the appeal, and he wins in the Court of Appeals on that issue. And the state appeals. What's that? On self-defense. He will ask for a jury charge on the state of mind of the juvenile on self-defense, and it was denied, even though Chris told the court, look, it's going to get reversed on that issue. So it gets reversed. State took it up to the Supreme Court, and he ended up, how long did that take? 3-4 years? Yeah. Oh, yeah. I mean, we're watching this kid now. He's 16, 16 years old now. And then finally what happens is Judge Schneider ends up releasing him. He's been in custody the whole time. He was in TJJD. Between detention and TJJD, 5 years. He's incarcerated. He finally gets released back to the custody of his mother, Deborah, even though that wasn't the ideal thing, but there was no other place to put him. So he goes home with his mother. He's now approaching 18 years old. This charge is still going on. Chris is ready to go to trial again. And then finally, right before his 18th birthday, and I guess Bill was still involved in it, Hawkins? He retired. After Bill leaves the office, the state then abandons the determinate sentencing, which is just a strike of a pen, and he's got 2 months till his 18th birthday. Let him plead to indeterminate murder, probation till 18. So he was on a 2-month probation, finishes that up at 18, and I don't remember yet. Brian Fisher did the sealing. I don't remember what the time, whether it was 21 or 21 probably back then. Sealed his record, and he's graduated college. He's about 24 years old now. So I mean that was the most unusual case I think ever down in the juvenile courthouse. And Judge Schneider and Chris became best friends after that case, even during it. But they're absolute best friends. And one thing about Judge Schneider, and I know the other judges too, they will not deny money for experts. He spent $105,000 on experts in that case, and rightfully so. It was a battle of experts. There were a lot of experts in that case. So fantastic result. He knows juvenile law because he had to do this stuff. That was a real test. So I want to congratulate him on that case, on the Loester case. Okay, now Chris is going to talk about school disciplinary issues, which if you're on the Harris County Criminal Listserv Association, everyone that has a question about school issues, they always say, hire Chris Tritico. That is one of his specialties. I mean, he's done federal death penalty stuff. He defended one of the Oklahoma City bombers, death penalty case. So, I mean, he's done it all. But school issues is a very big deal that Chris does, that a lot of the people in here, including myself, we're like, well, we don't mess with the school stuff. We handle the juvenile delinquency case. Well, he messes with both and knows how to deal with the school boards and the ISDs and all that. So he's going to talk to you about school disciplinary issues. Here's Chris.
Just to conclude the Loester, when the case was reversed, I told Judge Schneider on the record, if you do this case will be reversed on this point. And so when it got reversed, I was in district court. My secretary called and said, we just got the decision and Loester was reversed. I said, what was the reason? She said, on that point. So I walked over here and I opened the door to 315th, and of course it was packed like it always is, and it was like an E.F. Hutton commercial. Everybody stopped talking, and everybody looked at me, and Judge Schneider was on the bench. I said, I just came by to gloat. And he said, get in my chambers. All right, so I am one of the few lawyers in Texas, as I said, that handles school law and criminal law. I never intended to handle school law when I was in law school. I didn't even know that area of law existed. I didn't know what it was. All I knew about school law was getting sent to detention when I was in high school. But I backed into this 30 days after I got out of law school. I was hired by the Houston Federation of Teachers, the biggest teachers union in Texas, to be their general counsel. And I now represent 5 teachers unions in the Harris County area. I represent almost 10,000 teachers. And that has become an area that has been quite lucrative. Thank you. And and it's bled into this area of representing students and student discipline matters. And so it's become quite a little fun little area of law for me. So we're going to talk about they wanted me to talk about student discipline because it really affects this area here. And so I'm going to talk a little bit about this. Throughout this, we have used the HISD Student Code of Conduct. When I first started this, it was the Code of Student Conduct, and I think that someone in the state hired somebody for $500,000 to do a study on how to discipline children, and the only thing they did was change to Student Code of Conduct. It makes more sense the other way, but it's now the Student Code of Conduct. But if you get a kid from another district, every school district by law has to have a Student Code of Conduct, but they are not the same. All right, there's slight differences to each one because each school district gets to make their own. They all look the same, but they don't necessarily read the same. But there are certain aspects of them that are the same. So don't assume if you've read through HISDs that they're all going to be the same. They're not necessarily the same. There are certain things that you need to know because everyone likes to use initials for everything. So DAEP is a disciplinary alternative education program. ISS is in-school suspension. SRC is the Student Referral Center. OSS is out-of-school suspension. And JJAEP, which y'all are probably all familiar with, is the Harris County Juvenile Justice Alternative Education Program. DAEP and JJAEP will be the same for every school district. Those three in the middle may have totally different names in different school districts. So you may be talking to some kid and he'll throw out some, I was in, and he'll use some initials and you'll go, I don't know what that is. And they'll tell you, and it will be their in-school suspension or their version of a DAEP, which is the District Alternative Education Program. Every school district has to have a separate campus, which is their DAEP, where they send kids who can't get along at their home campus. That's what a DAEP is. And so, but they may call it something different, you know, the nice place or some crap like that. I don't know. All right. So each school district must have, as I said, a student code of conduct. It's required by Chapter 37 of the Texas Education Code. And the school district's student code of conduct is online at every school district has it online on their webpage. As I said, they're not all necessarily the same. It establishes standards of student conduct, specifies circumstances for removals, and standards for removal of DAEP. Outlines conditions for suspensions or expulsions, and it specifies the consideration is given to self-defense. That is a relatively new thing that the legislature mandated about, I don't know, 8 to 10 years ago. The legislature finally woke up and said, maybe we ought to let them defend themselves at these things. It was not, for a while, you'd go to these meetings and they said, we don't care if he was defending himself. He got in a fight, he's out. And it just didn't matter. But now you can use self-defense and other defenses. Specifies that consideration is given to the intent or lack of intent at the time the student engaged in the conduct. It also requires now, which I didn't put in here for some reason, that at a student discipline hearing, they must look at the student's background before instituting a punishment. And so if you have a kid who's never been in trouble before under certain circumstances, it may help to point that out. If the conduct is a Title V under the Penal Code conduct, it doesn't matter that they've been a good kid and never been tardy before. It's just not going to matter, okay? Specifies that consideration is given to the student's disciplinary. There it is, disciplinary history. I did put it in there. You have to give consideration to disciplinary history. Specifies that consideration is to be given to a disability that sustainably impairs the student's capacity to appreciate the wrongfulness of the student's conduct. I'm going to talk about that a little bit more in a minute. Provides guidelines for setting the length of term of DAP removal and expulsion. Prohibits bullying, harassment, and the making of a hit list. Hit lists are very big things right now in schools. I don't know what's going on, but the hit list problem is pretty big in high schools right now and junior highs. Or, I'm sorry, middle schools. We can't call them junior highs anymore. It's demeaning to the children to say that they're in junior high. Hit list is a list of children that you want to do bad things to. And adults, yes. Provides as appropriate for students at each grade level methods, including options managing students in the classroom and school grounds, disciplining students, preventing. It's just provides the method by which we're going to go through and discipline the kids. Now, here's the students with disabilities who are in special education classes cannot be disciplined under the Student Code of Conduct until an ARD committee is met. ARD committee is admission, dismissal, and review. That is the way kids get into special ed, stay in special ed, or get released from special ed. All right, that's what an ARD committee is. In other words, federal law says that if a kid who is in special ed acts up, the ARD committee must meet and determine if the conduct was a manifestation of the child's disability. If it was, they cannot be punished at school. That is very, very, very important to a student discipline matter. And it may be very, very important to you in a juvenile court setting. If you are representing a child who is charged, who put the top on this? Might have been me. If you are representing a child who has been ARDed into special ed, who has been charged with a crime, they will have a student discipline hearing. Do not allow that child to go to an ARD meeting unrepresented. Further, if you have never done special education work, do not go to that ARD meeting and represent that child. Okay? Because special education is a very highly specialized area. I don't do it. Okay? About 25 years ago, I said, this might be a very lucrative area of the law. And so I told my assistant and my associate, I said, let's gather the documents we need to figure out special ed. It was about as big as the tax code, and it took me about 30 seconds to say, I don't want to do this. So we have since found other lawyers who do this. I'll come to you just a second. Found other lawyers who do this, and we send families with special education children to other lawyers who specialize in special ed. And these manifestation ARDs are very important because you can get a wealth of information to assist you in a criminal prosecution and win that criminal prosecution from the manifestation ARD. But if you let them go unrepresented, that ARD will last about a minute and a half, because they're going to say, here's what happened. It was not a manifestation. Boom! Send him out. Yes, ma'am.
So will this also count for students who are under 504? Because 504 students also get an honor, but they're not specific.
See, and that's where you just went about 6 miles above my understanding. That's why I have experts who help me with that. Anytime someone says to me special ed or 504, I say, let's stop right here, and we're going to get somebody on the phone who can help us with this. Because I believe a 504 student probably has to have a manifestation ARD as well. But that's where I would stop, and I would get one of my people on the phone that I consult with on that, and I'd get them on the phone right then. But you don't want to let this ARD meeting happen, because you're going to get a wealth of information there. The ARD committee may ultimately determine it was not a manifestation. That doesn't mean you don't get that information, that you may assist you in defending this kid. Okay? All right. There are 5 levels of offenses. I use offense in the administrative sense here. 5 levels of offenses in the student code of conduct. We're going to talk about levels 3 through 5 because levels 1 and 2 are the minor offenses, like spitballs and stuff in the classroom and tardies and things, and that's not going to apply to us. Level 3 are suspensions and optional removal to the DAEP. Level 4 is required placement in the DAEP, and level 5 is expulsion for serious offenses. So that's what we're going to try to go through. I don't know how much time we have, and that lady's going to come yell at me in a little bit, so we'll get kind of move through it. Level 3, suspension or optional removal to DAEP. Level 3 acts include misconduct for which an administrator may suspend the student, place the student in in-school suspension, or if the administrator finds the level 3 misconduct to be serious or persistent, refer the student to the district level DAEP. As I said, that is a separate campus away from the students. Like I grew up in Spring Branch and went to Spring Branch High School. Spring Branch High School no longer exists. That school is now, probably appropriately, the DAEP campus in Spring Branch. So, level 3 acts of misconduct: mutual combat, what we called fighting, gambling / possession of drug paraphernalia. I have no idea why those are combined in the student code of conduct. That makes no sense to me. Misdemeanor stealing or theft of property, chronic cutting of classes, knowingly making a false report against a staff member, changing and falsifying school records. That happens chronically lately. I've had, I don't know how many kids in my office, and I call that the Epstein's mother. For changing, signing your mother's name. Is there nobody here that watched old enough to see Welcome Back, Kotter? Nobody. Thank you. Harassment, dating violence, including threatening to cause harm or bodily injury. And this, I love this, sexually intimidating conduct. I have no idea what that means, but that's in there. Causing physical damage to the property of another student, subjecting another to physical confinement or restraint. and maliciously taking an action that substantially harms another student's physical or emotional health. This is really the harassing or dating violence that you end up with mostly on this. Possession of live ammunition or bullets. We don't get that much because right now we have a rash of kids bringing guns on campus, and probably every one of the rooms had at least one of those. I've had 6 or 10 of those in the last 12 months. Misdemeanor criminal mischief, use of school computers or other equipment to transmit, receive, view, or display obscene, vulgar, sexually explicit, or racist media. That is a chronic problem on school campuses right now with not the racist, but the sexually explicit material. When I was growing up, we had a phone in the hallway, and your mother answered it. So we didn't have the ability to send sexually explicit material to each other. But I don't know what's going on with this. And I talk at schools all the time, and I say, don't raise your hand, but if you have your girlfriend or your boyfriend's nude picture on your phone, you have committed a crime. And all the blood drains out of there. It's very fun to talk and get them thinking about the fact that that's a crime. Possession or use of any prescription or non-prescription drug, medicine, vitamin. You can get kicked off school for bringing Flintstone with you to school. Other chemical or violation of guidelines for dispensing medicines at school. The rule is at school, if you're going to take prescription medicines to school, you have to take it to the nurse and leave it there with a note from your mother, not Epstein's mother, your mother or father, and the nurse has to dispense the medicine, including vitamins. The most famous case I've ever seen in Texas was a girl had a Midol in her purse because she had a problem with her menstrual cycle, and her parent gave her a Midol and said, in 4 hours, take this and you won't have an issue. And she was expelled because her mother gave her a Midol. There it is right there. Sexting. That's what I was talking about. That is the biggest single issue going on in schools right now, is sexting among kids. I don't understand it, but it happens all the time. I have at least 3 kids a month in my office with sexting allegations going on. What you need to be talking to kids about when you're representing them for sexting issues, the legislature made it a Class C misdemeanor if it's just among a relationship issue, but what they don't understand is it has to remain among those two. So if my girlfriend sent me a naked photo and I just kept it on my phone, it's a Class C misdemeanor. If my girlfriend is hot and I decided to send it to the entire football team, I have now committed the offense of child pornography, distribution of child pornography. And that's always a fun conversation when you explain that to the 16-year-old boy. So what I do when they come into my office with those issues, I seize their phone and their iPad, and I don't give it back. And that's always a fun conversation, too. You're not getting this back, son. Why? Because I can't trust you, and we're not going to let this problem get any worse than it is. And Mom and Dad just going to have to buy you a new phone. And I've got 40 upstairs in my office, and one day they can come back and get them. But while the statute's running, they're just sitting up there turned off, so we can kind of make sure that we don't grow problems. And I think that's the best way we can protect them. I don't know what's going to happen with this situation. It's getting worse and worse and worse. I don't know what's on that phone. I've never looked at it, never opened it. I don't have the codes. I don't want them. It's just a turned off phone with no charge. That's what it is. I don't know what's on there. Level 4, required removal to DAEP. Student can be removed from the classroom and placed in DAEP when the student engages in any conduct listed under Level 4. Oh, and by the way, back to the phones. When they are charged with a crime and you need to get stuff off that phone, there's a law in Texas that if you delete stuff off there, it's a new crime. And the kids think that they're helping themselves by deleting it. So now they've committed a new crime, and there may be stuff on there that's helpful to you, but they've deleted everything. You can get an expert to find that stuff, unless it's Snapchat which they're all using now. Once it goes off Snapchat, it's gone forever. If they're using something else, it's just texting, regular texting. You can get an expert, and we've got 2 that we've used, to go get that stuff. It's still on the phone. It's just going to cost $2,500 to go get it off the phone because they thought they were being smart by deleting it. And so that's always fun to tell Dad, give me $2,500 and I'll get that stuff off the phone because we're going to need it because he deleted it. Okay. But you can still get the evidence. All right. Student commit shall be removed from and placed in DAP when the student engages in any conduct listed under Level 4. Placements may not generally exceed 1 year unless it's determined that the student is a threat to the safety of the other students, the district employees, and it's in the best interest of the student. Son, I find it's in the best interest of you that we send you away for the next year. Good luck. Additionally, there is no limitation on the length of the placement of a student in DAP if the student is engaged in sexual assault or aggravated sexual assault against another student. I have never had that happen, ever. Where it's been more than a year. I've never had one for a year. So that's in there, but I've never had it happen. Level 4 acts include felony conduct that are, there are 3 instances of felony conduct that must be referred to DAP. If the placement is in accordance with this section for any period considered necessary on the basis of the circumstances and facts, however, the student must be reviewed every 120 days. Those reviews, if the case is still going on, if serious conduct, those reviews are nothing. How you doing, son? Good. Case still going on? Good. Good luck. We'll see you in 3 months. Okay, those circumstances include any conduct punishable as a felony on campus, at a school-related function or activity, or within 300 feet of the school property line. 2, while enrolled in HISD, and regardless of the location of the offense, receiving deferred prosecution or a finding by the court or a jury of delinquent conduct under the Family Code. This is the best one. Or a reasonable belief by the principal that the student has committed a felony under Title V. I love that. Last night, son, I had a dream that you committed a Title V offense. Good luck to you. Now, in the third way, Level 4 misconduct also includes a finding that the student has engaged in any of the following conduct on a school campus or at a school-related activity or within 300 feet of the school. Now, this is a whole laundry list of every crime you can ever think of. Engaging in assault, selling, giving, delivering any kind of marijuana, controlled drug, controlled substance, selling, delivering dangerous drugs. What was that last one? Possessing and being under the influence of alcohol. That's a big one. Alcohol. Kids are putting vodka in water bottles. I was joking about earlier. Kids put vodka in water bottles and walk around campus all day long drinking their vodka, which is fine in the morning. By 6th or 7th period, it really becomes an issue for them, which their brain has not contemplated that by the 6th or 7th period it starts to look bad, but that's what they're doing. Selling, giving, and delivering alcoholic beverages to another person, health code violations, designer drugs, synthetic marijuana is becoming a huge issue, and I can't get through to kids that it's such a big problem what they're doing to their brains with synthetic marijuana, but that is a big, big problem on campus right now. Public lewdness and indecent exposure is another problem because the hormones are raging, and you find any corner and let's just knock one out, and then they get sent off to DAP or worse. Thank you for laughing at that. And they don't think about the fact that there's cameras. Okay, this is on camera, son. What were you thinking about? Do you want to see the film? It wasn't that good. It's a bad movie. Felony theft, property in amount of greater than $750, burglary of an HISD facility, defacing school property with graffiti, other than a means that results in a loss or destruction of property in amount less than $20,000. That's a felony. They're not really prosecuting that much anymore, but when they passed that and put that in the penal code, do you remember when they put that in the penal code? It's about 10 years ago, maybe longer than that. They were filing those like crazy, and I think they finally realized this is kind of stupid. Some kid puts a mark on the wall with a magic marker, and we're going to make him a felon. So they really quit prosecuting that, but schools take it very seriously, and they will kick you out for that. Class C assault is a level 4 offense. I don't understand that at all. Participation in illegal organizations such as a fraternity, sorority, secret gang, cult, or other criminal combination. I don't know what that means. Prohibited by law. Possessing a knife, repeated possession of guns, BB guns, discharging mace, and possession of a replica gun. I've never had one of those. Other things. Now, the bottom one here is what I want to talk about. Well, hacking computers again, and the last two is hacking. Again, I've got that all over the place. I've got 3 of those pending right now with kids that are accused of hacking in to change grades. And, I don't know who laughed at that, but that happens all the time right now. And I don't know what's going on. And I think it's just because kids have gotten so damn smart with computers that they're able to do that and hack in and not realizing that they have other geeks that are as smart as them who now work for the school district and are able to figure this out. Okay? You're not smarter than them anymore. Okay? Because the geeks who developed the computers now work for the school district, son. Okay? They get it. They got it. They figured you out. All right. So I've got 3 of those pending right now. Level 4 acts that require or that you can get suspended for regardless of where it happened is conduct involving a public school that contains the elements of a false alarm. Regardless, if you do a false alarm, regardless of where it happened, you are gone. Making a hit list. Somebody asked me about that. This is happening everywhere. Now, every hit list case I have ever had involved a mental health issue. Every one. If you get someone accused of making a hit list, your first thought needs to be there's a mental health issue going on here, and you need to look at it, pay attention to it, and get them evaluated by a private forensic psychiatrist or psychologist. I have never had one yet that didn't have some form of mental health.
You know, HISD has a thing where if you threaten to kill or such and such, they make the kids go through a psychological evaluation to see whether or not the threat is reasonable or if it was just a kid blabbing off.
Right.
Is that something that's supposed to be under that Amy's Law, whatever it's called?
Well, I haven't had that with HISD yet. I've had it with outlying school districts, so I'm not familiar with their program. But I would want my own forensic doctor to make that call because the Harris County District Attorney's Office is going to file that case. And so I want my own doctor to be looking at this and making these evaluations because I'm not going to use HISD's doctor. I want my own. Okay, and I've never had one of these hit list cases that didn't have a mental health issue involved. Every time. Okay, level 5. These are your most serious cases, and these are required expulsions. When the expulsion, there may be some optional, but most of them are required. Most serious misbehavior and or illegal acts that threaten to impair the educational efficiency of the school. When expulsion is optional, the student may be expelled and placed in JJAEP, and they always love that. I've never had a parent come to me and say, "Can we just send them to JJAEP?" That was humor. Every now and then, and it does say in the code that they can go to DAEP. The school is never going to agree to that, ever. They're gonna expel them or send them to JJAEP. But they can drop it to a level 4 and send them to DAEP for engaging in the following misconduct or within 300 feet of the school or while attending a school-sponsored or school-related activity. And then you go back through the penal code. And it's just all the same stuff we've already been through, so I'm not going to spend a lot of time reading all this stuff again. But it gets back up into the same thing I read, but at the higher level and the higher level of conduct. It just steps it up to the higher grade of felonies, and if it's repeated conduct. So if they gave you a break once and you turn around and did it again, they're going to jump it up to a level 5 and they're going to expel you. Same things. Now here, then you get to the aggravated assaults and aggravated sexual assaults, murder and capital murder. I've never had anyone charged with capital murder that they said, "Yeah, sure, come on back, no problem." breach of computer. If you're charged with breach of computer security, they will expel. They're not bringing you back. They're just gone. Oh, and I'm glad I thought about that. Thank you. Parents tend to think that if the kid gets a DAEP placement, let's say for 45 days, and they just say, well, I'm not doing that. I'm not sending my kid to DAEP. I'm going to withdraw them from school. That DAEP placement does not go away. And then if they come back and enroll them back into school, or they move across town and go to another high school, that DAEP placement follows them, and the new school will enforce it. Okay? So they think they just did something, and they're going to go across town, and then when they enroll, they say, well, you got to go to DAP for 45 days. So they didn't do anything. Just a second. They didn't do anything. Further, they may have the money to go to private school, so they say, well, we'll just withdraw from here. We'll go to private school. A private school will not take a child who is trying to escape a public school punishment. So all they have done is taken their kid out of school and delayed the punishment. Now you can homeschool. If you have the ability to do that and you have the brain to teach a kid who doesn't want to learn, then you can try that at home. Now you've just created a kid who hadn't learned anything. That's what you want to do. But the kid has to have the punishment. Right. Nobody will take you. If you're a really rich person and you can go buy your way into some of these private schools and you can do it, most private schools, when they learn that there's a pending punishment, will deny the application. I've only seen one or two times where they were able to get past it, and that's because the chairman of the board or something, and they're able to say, let them in anyway. Okay? All right. We're almost out of time. So here's the ways that you get kicked out of school on a level 5 offense. You've received deferred prosecution. You've been found to have engaged in delinquent conduct. You're charged with delinquent conduct for level 5. You're charged with engaging in delinquent conduct. I don't know what that means other than the other one. You're referred to a juvenile court for delinquent conduct. You're on probation or deferred for delinquent conduct, or you're convicted for delinquent conduct. The only thing that should have been on the bottom here is you ever thought about engaging in delinquent conduct. Now, if you've been arrested, here's some more. I've been arrested for engaging in delinquent conduct. The principal must then determine if the student's presence in the classroom threatens the safety of the students, the teachers, and will be detrimental to the educational process. They will always find that for a level 5. I don't know what this screen means. I don't know who wrote this. Reading it makes you a little dumber. Some of the offenses listed are not punishable as felonies. Capital murder. Really? Who wrote this? Don't look at it. Just divert your eyes. All right. The expulsion shall last until the student graduates from high school. The Title V felony charges are dismissed or reduced to a misdemeanor, and the student completes the term of the placement or is assigned to another program. A decision under this section is final and may not be appealed. That's it. But it has to be reviewed every 120 days. They bring you in. Hey, how's that capital murder case going? Oh, it's going fine. Good. We'll see you in 120 days. You're not going to get the review unless it gets reduced to a misdemeanor or it gets dismissed or you win at trial. That's it. The review is not going to help. Defenses. Here's the defenses, and this is the best part of this. Self-defense, the student's discipline history, intent or lack of intent at the time the student engaged in the conduct, student's disability that substantially impairs the student's capacity to appreciate the wrongfulness of the student's conduct. If you're going to do one of these hearings and you have a really good self-defense case, I'm not sure I would ever go to a student discipline hearing and put my self-defense case on. Okay? So let's think about that. You're looking at me like, are you crazy? So where do I want the state to learn about my self-defense issues? Do I want to put my evidence on at a student discipline hearing that's going to be tape recorded and have my client testify about the facts where the state can subpoena it and then get it and learn about it and prepare their case around it so that I can get Johnny back at high school? Or do I want to save those bullets for trial and go to the student discipline hearing and I'm going to tell him, I'm sorry, but you're about to get expelled until this case is over. We're going to go to the student discipline hearing and we're going to get all of their evidence that will help us in your case. And in the meantime, you're going to get expelled. I'm sorry, but it's better for you. Now, if I think that my case is so rock solid that there's nothing the state can do, I might go and do that. But that's going to be a rare case. Okay? That's your decision to decide. But from a criminal defense standpoint, I don't think there's ever been a case that I'm willing to go when my client is facing a serious felony and put that evidence on at a student discipline hearing where I've got such a small possibility of winning anyway. What I am going to do is get somebody to do that ARD. All right? But I'm not going to let my client testify at a student discipline hearing where it might hurt him in the criminal case where the sanctions are real. Okay? I just put this in here to talk about the fact that the Harris County has been filing all of these gun cases and terroristic threat cases. There is a provision in the Texas Education Code that says in a terroristic threat case, if the child did not have access to a weapon, that child cannot be charged with a felony. Find that. Very important. It's the more specific charge on a terroristic threat. If the child did not have access to a weapon, the child cannot be charged with a felony. I forgot to put the site in here. Well, I'm sorry, somebody forgot to put the site in here. It might be me. But it's in the Texas Education Code, and it's the more specific site. And Steve Halpert might actually know what that site is. It's a very good tool when you're defending someone on a terroristic threat case at a campus. All right. I think that's the last of those. Yeah. So if you have any questions, I got about 2 or 3 minutes. That lady's not here to steal my time. 3 minutes. Anybody have any questions? Yes, sir. Chris. My name's Chris. Steve's out there. He's heavier than I am. I've been losing weight. That's all right. Student disciplinary, you have 3 levels of appeal. It depends on the allegation, what it is. But typically, you go to the principal, and then you go to the superintendent, and rarely will they let you go above that. Typically, it ends with the superintendent, 2 levels. It's a good question. Yes, sir. I don't know the answer to that. It just says access to a weapon. And so what I've done is I send my investigator to the house to photograph everything and document that they don't own any weapons. And I put all that together, and I prepare that to get it dropped from a felony to a misdemeanor, and it has been rather successful so far. Good question. I haven't tried one yet because I've gotten them dropped to a misdemeanor, and that's generally been what all that my clients wanted. Anybody else? Anybody else? Well, I want to thank you for listening to me for the last hour and a half. I'm going to go home. Thank you.
And prematurely, our next speaker also gets a round of applause for taking on 2 presentations, Kelly Opot. And you're going to learn everything you need to know about dual status youth, which is now a very big topic in the juvenile courts. Take it home, Kelly.
Hello, everybody. Good afternoon. So I was just talking about how I had the pleasure of being the very first and now right before lunch. So thank you, Steve and John, for that. And I actually, because I get to go twice, there was something that I remembered on the way home that I forgot to mention about brain development that I was thinking about. So that is one of the benefits. Something that comes up often in juvenile justice, in particular for attorneys and prosecutors, or defense attorneys and prosecutors, is this idea that when we're focusing on brain development, there seems to be a belief that we're saying that children shouldn't have consequences. and that you should just let everybody go. And that's not the focus. The focus is really about the consequence. Children should still have consequences, and even the work around trauma-informed care and trauma-based interventions say children have consequences for their choices. We all have consequences for our choices. The point is that the consequences need to be developmentally appropriate. And right now, most of what we have in our juvenile systems are adult consequences for juvenile behaviors. And so that's just something to keep in mind as, you know, you hear that and you'll get pushback. And I know there's pushback around brain science as being too uppity. We hear that on a state level. And so just, you know, those are kind of the arguments that are made against it, just so that you know that, taking that into the work that you do. So today I'm going to talk about our work in Harris County around dual status youth, and it's something that some of you have probably heard about. It's getting a lot of attention because our new judges are all dedicated to it, and we have been in existence for a while. So I'm going to tell you a little bit about the initiative broadly and what it means to you working inside the juvenile system. So our initiative began in around October of 2016. And kind of depending on who you talk to about this work, different people say they started it, which is fine. So you will probably meet many people who say they started the Dual Status Youth Initiative. Cool. Just let them tell you that, because they probably did in some way. But it really started community-based and from a group of people both in probation and CPS, but also people that were advocates working with children that were saying, hey, you know, we're noticing that kids that are in the CPS system seem to be getting deeper into the juvenile justice system, or kids that are in the juvenile justice system and maybe they don't have anywhere to go, get stuck in detention or places like that longer because CPS can't figure out how to take care of them. So these were the issues that folks were bringing up and saying, we've got to do better. We've got to coordinate better. What can we do? And so people started meeting collaboratively, just kind of on their own. And Houston Endowment was a part of that very early on and said, you know, sounds like a really important issue that could affect two big youth serving systems that we have in Harris County and the state. Why don't we put some effort behind this and really create a steering committee? And through that steering committee, they decided we want to have full-time staff to support this work. And there have been efforts in the past to work on this. And, you know, one of the things, Tom Brooks was a part of it when Tom Brooks was still here. And he said, you know, we've tried to do this before, but we needed someone who was neutral. We needed someone who could keep this ball rolling, because it ended up being just another job of someone in the juvenile probation department or just another job of someone in CPS. And it fell off when their real job ended up taking too much time. So they formed the Dual Status Youth Initiative, which you'll hear it called that sometimes, which we've since renamed with young people to the Harris County Youth Collective. And these are our goals as a collective. We really want, you know, our goal overall is really to have better outcomes for kids who are involved in both systems and make sure that they're ready to be adults, make sure that they are ready and receive the education that they need and can take care of themselves. We also really have an eye to how we can prevent children from becoming dual status. And so a lot of the coordination that happens is through that. This is just a picture of all of the agencies. I know you probably can't read everybody that's in there, but all of the agencies that are involved in our work. And it's important for you all to know this, just because you'll probably only see it from the judicial side, maybe the probation side, but there are lots of organizations that are dedicated to working with children and trying to figure out how we support children once they become dual status. So it includes school districts, it includes the Children's Assessment Center and Harris County CPS, but also the Harris Center, which is our mental health authority. It includes lots of advocate attorneys. Judges are working with us, as well as attorneys, the county attorney, the district attorney. So there's lots of folks that are participating in this to make sure that we're doing the best job that we can for youth. And this is just the structure. It's boring. You don't care about that. So one of the things that you need to know about how we are implementing the work that we're doing is through the Georgetown Center for Juvenile Justice Reform. So they are a national organization, Georgetown University, based out of D.C., and we're using their crossover youth practice model, which is an evidence-based practice model that organization or communities use across the country. In Texas, Bexar County also uses this model. Travis County also uses this model. El Paso County, Dallas, and Tarrant have all done some sort of work around the crossover youth practice model. So there's also beginning to be a shared language that we can use about young people throughout the state. We call it dual status because it's Harris County and we like to do that. But most other places call it crossover youth. And so there are differences between the two. Those differences don't really matter to those of you that are working with youth that are dual system involved. Our focus in Harris County are those right now are those that are dually involved. So right now have current involvement in both systems. So who are dual status youth, if you haven't ever heard of them? Have any of you ever represented a dual status youth or know about dual status youth? Okay, lots of you. Cool. So it is children that are both in child protective services and juvenile justice involvement broadly, right? What we're focusing on in Harris County are the 6 different pathways that children can become dual status. And the first 3 are about kids that are involved in the CPS system. So they're in custody, which is called TMC or PMC, so temporary or permanent managing conservatorship, which means they are in custody of the state in some way, and then get involved in juvenile probation. Either they're in detention, they get diverted, they get arrested and released. Those are the pathways that we're measuring and tracking children. You can also, another pathway is something where children come in through the juvenile justice system and then CPS gets called and involved. So I'm sure some of you have experienced that. That's actually the largest one that we're seeing in Harris County since we started tracking this, and there's a variety of reasons that that's probably happening. The 2 that we haven't really implemented yet are around children and families that are in family-based services, and part of that is because it's voluntary for families. So if they're in family-based services, it's voluntary for them to share information that they're justice involved, and there's a variety of reasons that they might not want to do that. And so, we haven't focused as much on those. We've started implementing pathways and tracking young people that fall into these pathways in May of 2018. So there was a lot of work gathering up what it would look like, how we'd put that together. We have data to start tracking who these young people are. That said, our data systems don't automatically identify youth, and so a lot of it is just figuring it out and manual reporting and the hard work of juvenile probation and DFPS. So these are the things that we know about dual status youth. The defining characteristics, like I said, TMC and PMC, 10 to 17, because outside of that, you're involved with CPS until you're 18, technically juvenile probation until you're 17, and really any involvement in juvenile probation. So pre or post adjudicated, they can be in diversionary programs. So it's really any level of involvement with juvenile probation. Some of the statistics that we have on youth that we have been able to gather both in kind of a longitudinal data set matching that we did with Department of Family and Protective Services, as well as this weekly tracking that we are doing. And we have done an in-depth study of a small group of youth that were in joint custody. So that means in TMC and PMC and also in CJPO. So, living in one of the juvenile facilities. Because we can't automatically track them, we don't know how many kids are dual status every year. Based on the data that we have, we think it's about 200 that are newly dual status every year. There are some complexities to that probably aren't that important to you. But one of the things to know that if you're working with a child and they're in CPS, they might not be from Harris County, which some of you probably know that. But so there can be a little bit of difference of how those kids are handled in court. But there are a lot of children who are from other counties that move here because we have a large number of residential treatment centers where people where DFPS sends adolescents who are in need. So we have a lot of kids that are living in our region, who are living in residential treatment centers, and oftentimes the charges stem from their behaviors inside those residential treatment centers, which is problematic in and of itself. Not something we're going to dive into today, but I and some of the dual status attorneys that are here today that I'll volunteer up for you will probably be willing to talk to you about that. Right now, in the data that we have, the average age is 14.8 years old for dual status youth. Interestingly, this match that we did with DFPS, so this is the data we've been collecting, our older data showed that the average age was like 12.6. So we're going to try to figure out what that's about, kind of what the discrepancy is if we're maybe tracking a certain number of youth versus others. 55% Black or African American, 24% white, 21% Hispanic, and we believe that that is an overrepresentation of white, as DFPS collects separately ethnicity and race, and juvenile probation collects them together. And so we think it's an overrepresentation of white, and I'm sure based on your own experiences, that's probably the case for you. But you can see huge disparities compared to general population of who is involved in dual status. Another really interesting one is this gender statistic that it's 48% female and 52% male. And in the general juvenile population, females make up less than 20%. And so, there's a little bit of what's going on here, that there's an overrepresentation of girls or females in dual status work. Kind of thinking about our policies and the way that we police girls and police girls of color within our systems. So it's just something to think about. And also 52% of them have run away at some point, which is probably something that a lot of you have dealt with. And that's something that we're thinking about what do you do for kids who are running away? Because we know that the best place for them is not the detention center, right? We have dual status teams on both the DFPS and juvenile probation side. So that's another thing that you will run into from time to time if you're working with kids who are dual status. There are dedicated folks within DFPS, so all the way up to a director at the program level, to dedicated actual caseworkers that are working with youth. So it's people that understand, and this is important because it's people that understand the juvenile side. Because what has been happening before is there's a little bit of passing off, right? CPS might say, oh, you're in juvenile now, that's your responsibility, and kind of step back. And that was the thing that we didn't want to happen. So now these two are working together, really understanding each other's systems. On the juvenile probation side, we have a juvenile probation supervisor who many of you probably know, Allison McGallion, who's in the Harris County Juvenile Probation Department. And there are 4 JPOs working under her. And the way that this is set up in probation is different than other specialty areas, because these probation officers serve as their JPOs, and this is relatively new, from start to finish. So unlike other cases where kids are getting a court officer, a detention officer, a placement officer, a field officer, we were finding that there was a huge disconnect in trying to maintain services for youth. So the dual status unit stays with the child all the way through their juvenile probation involvement. If they go into a facility, they will still have an officer and a caseworker inside that facility, but the juvenile probation officer will stay connected to them. Yeah.
These CPS matters that are created within just the juvenile courts, what permission do you have from the district court to share their CPS data with your juvenile?
I'm not sure I fully understand your question.
There are CPS matters that are created just in the district courts.
Yes.
That have nothing to do with the juvenile courts. And seeing that the juvenile courts have exclusive jurisdiction over their issues, are you getting some kind of permission from the district courts?
Oh, like the family courts. Yeah. So this is the information sharing. The responsibility is actually within the two systems. So it's not attorney level. It's actually client system level as caseworkers. So the Department of Family and Protective Services and Juvenile Probation Department do have permission and actually are required by law to share information with each other to better serve children. So there are cases that their CPS side is in the family courts, not in the local district courts. Since the elections and the new judges have come in, we haven't been able to really connect with those family court judges as much as we had previously, but that's kind of on our books. And mostly just because, as with all the judges, they were bombarded with people trying to get in front of their face to say, like, oh, I've got this great new program and now I want to help you. So we've talked to some of them and we know them, but we are not requesting that their attorneys necessarily share information.
Yeah, that's not my question. I'm sorry. I guess my question is, within the family courts,
Mm-hmm.
I'm in, the 507, and I have a CPS matter, and that child is also here.
Mm-hmm.
Juvenile. Are you saying that the system is set up where it's automatically the data is shared, even though we're dealing with the juvenile courts, we have exclusive jurisdiction over their issues, but not necessarily over the family issues? That information is automatically shared. Is that what you're telling me?
Automatically is where you're catching me, because it's not automatically shared. So the court level information is not necessarily automatically shared. The information that is shared, and I know that there are concerns about sharing information on the juvenile side and CPS side, and I'll let the attorneys who have to do that explain that a little bit more than I can. This is really about, and typically the coordination happens. I mean, the coordination will happen between the systems pre-adjudication, but we're not requesting that youth share information that is coming out of their CPS case that could harm their juvenile case, if that's the concern. Yeah, and so what is happening, and juvenile probation understands that and knows that and will advise, and attorneys will advise their children. The coordination that happens is really around where children can go and where they're going to live. So less about the process, which is part of the case as well. But yeah, does that answer? Okay. There's someone here that I'm not going to call out his name who will do a better job of answering that, but I will call out his name. So this is more about more the court system. So all these things are kind of happening outside of what's happening inside court, and that is important for the systems. That is important for the care of the child, because what's happening inside the court will happen, and then they're the responsibility of DFPS or juvenile probation, and perhaps not you anymore. We do have specialized attorneys that are working with dual status youth on the juvenile side that are assigned by court similarly to how our juvenile probation officers are assigned by court. So those include Kelly Grawl, Keisha Smith, Sean Hubbard, Ryan Mitchell, Matt Dexter, and Amanda Downing, and Margaret Lombardo. Some of them are here today. I've seen them. And so they can help answer those legal questions better than I can. But that has been really important for us, because we need juvenile attorneys, or we need defense attorneys that can understand both sides, understand what a child is going through on the CPS side, and understand kind of how those two pieces work together, and what needs to be protected ahead of adjudication versus what can be shared in terms of trying to identify the best services possible. We do also require that both DFPS and juvenile probation, but really DFPS is the big one, participate in each other's hearings. So the DFPS caseworker has to be coming to the juvenile probation here, or the delinquency hearing. They are supposed to show up. Yeah.
Would it be helpful for people who are attorney ad litem's for cases in the district courts to make the suggestion when, for instance, if I have a kid I'm representing and he would qualify for this, would that be helpful to the program and to the child? To make the suggestion to that district judge in the family court can we explore this for this kid?
Yeah, and this is not necessary. I mean, it is in a way. It's not necessarily just a specialized program. It's really focusing on the way that the systems work together. So unlike a specialty court program or the specialty programs of juvenile probation, there is a specialty unit, but the shift is really about how the systems work together rather than the specialized services that come out of it. So it's not like you refer to this program, but there will be, if a child is dually involved, and the chances are that those systems are tracking it because they do weekly match who they know. And so there is this shared information about who all these children are. And they're not all in 3, 13, 14, and 15. So most of the way that we've done that to date is through the county attorney's office. But it's definitely important for the judges to be talking to each other as well. And they generally do, from what I understand. And so, but if it's something that you know about, it is, as the attorney, it is definitely worth it to bring up to the judge. Yeah. We do also have a specialized prosecutor in the juvenile division. So Tricia Mason, who participates on our steering committee, is there consulting on the dual status cases on the juvenile side for the state. There are staffings and joint decision making. This is where things can get a little bit scary for defense attorneys, I think. And so there is absolutely, and we understand, again, both on the juvenile probation side and the CPS side, the need to withhold information that could be used against a child in their case. So we're never encouraging that. A lot of times the staffings that happen are post-adjudication, but sometimes they're pre-adjudication, and defense attorneys don't always participate in these for understandable reasons, but you will get reached out to say that this is happening. And so it's led by Department of Family and Protective Services. We'll say we're going to have this staffing. This kid is in detention, or he got arrested, she got arrested. Let's make sure that we all understand what's happening. First of all, so that she doesn't have to sit in detention for 3 weeks because we can't find a placement. And second of all, to make sure that all these parties know that there's all these parties involved. Because I've understood, and Judge Fisher and Judge Shapiro have both been a part of this since they were attorneys. And so I've understood from them that, there could often be a juvenile case that goes off and exists, and there it is. And the dependency case is also proceeding, and the two attorneys would never know, might never talk to each other, might not understand what's happening in the other. And so this is at least so that you have that line of communication. It also means that there's tons of people at these hearings, right? So there are a lot of people involved. There are also specialized guardians ad litem for dual status youth. So you are more than likely going to have, for a kid that's dually involved, they're going to have a guardian ad litem on the dependency and delinquency side, an attorney ad litem, a defense attorney. So there's already 4 people. You're going to have their caseworker. You're going to have their juvenile probation officer. They should have a child advocate as well, which is something that we've started recently, that will be beginning next month. And we have been specially training child advocates so that it is special child advocates that understand the issues between juvenile and CPS and can advocate for children based on that. So you're going to have larger hearings with tons and tons of people. And if there's a parent involved as well, them and all their attorneys as well. And our goal is really that the decisions that can be made, you can present a shared decision to the judges. And so that is in the best interest of the child, and that we are, in particular for these cases that might be coming through the juvenile side, we're really looking for alternatives to placing children in the CPS system, because it's not in a child's best interest to come into CPS care when they're 15 and 16 years old. Home might seem terrible, but coming into CPS care, if they weren't already facing abuse, they're almost guaranteed to. And so that's really what we're trying to look at, and more broadly, systemically, at where placements can be and how we better address the needs of children. You had a question?
Yeah, I think I understand what you're saying. However, if you bring in
Yeah.
for the dad, there's another reason why the kid should not be with the mother or the father. So
Yeah.
how is this tool? I mean,
So the
I don't know how.
how it's helpful, right? So we have heard that and we understand that. The child advocate will not be placed on the juvenile side. They'll still be on the dependency side. So it's not that the child advocate is brought in on their juvenile case. Their focus is still their dependency case. So they're still acting in that role. There are specialized guardians ad litem that are not child advocates that will be working on the juvenile side. And sometimes those don't match up. We have brought that to the attention of child advocates, and it is important that that is not the direction that they're going. We have created new trainings for them, and we've said, it needs to be a very specialized type of advocate that's working with children. It has to be teenager, and we are really focused on keeping the families together and the broader permanency goals. And we'll be tracking it. And if you see that, you can. I didn't put my contact information, but we need to know if it's happening where they're getting in the way. Then that's something that we need to know, and we can change it. Okay. So I hear and understand your concern, but our interest is definitely that children can be in family or family-like settings. That's all I have for you. So I wanted to give a couple minutes for questions if you have them before we go to lunch. Okay, no, thanks.